I can't tell. So for the camera person, just let me know when we're ready.
We're good.
All right, welcome everybody to the Committee on Mandatory Fee Arbitration. I'm the chair, Lorraine Walsh. We have some new faces in the room, so maybe we can go around and introduce ourselves first before I call the meeting to order. I'll start. I'm Lorraine Walsh. I've been the chair for about a year and a couple months, been on the committee since 2011. I'm an attorney in Walnut Creek. I'm a certified specialist in legal malpractice law.
Hi, Ken Bacon, presiding arbitrator, and I know Randy, I've met Andrew, I know Warren, so hi guys. That's good.
George Tuesdyker, a member of the committee since 2016, practicing in Seneca County.
Anahita Jamian, I'm a litigator in Pasadena, California. I've been on committee the last year, I think, and I haven't met any of you. Hello.
Lee Strauss, I think I met you guys in LA when we had the brief meeting. I have been on the committee since 2013 or so. I'm an assistant presiding arbitrator with Ken. I'm a vice chair on the committee this year.
Who am I?
Well, so many committees. I don't know like what the title is. I work closely with Sharon because I'm part of the LA County Bar's program as well.
Hi, Nick Mariachi. I'm an attorney from the Long Beach area. Actually running the MLK program for the association. I was a former chair of this committee. Roy Zuckerman, retired bank lawyer. Started my second year.
And I provide administrative and oversight and support to Isabel and Elizabeth and the work. Nice to meet you all.
Randy DeFentorm, also with the Office of Professional Competence. Get to work with Lauren and Andrew and Mimi in all of the activities of the office, and we really see this as a great opportunity to assist the mandatory fee arbitration program in growing and continuing and improving in its new home within the Office of Professional Competence. So it's really a privilege, I say, to be able to incorporate that into our operations.
Good morning, everybody. My name is Andrew Tuft. I did have the pleasure and opportunity to meet many of you last month in Los Angeles when we had our joint meeting between the Committee on Professional Responsibility and Conduct, which I primarily staff, and you all. I'm the supervising attorney in the Office of Professional Competence. I'll be working closely with Isabel and Elizabeth to help staff and serve the functions of the fee arbitration program going forward. We're excited to work with that program, and as Randy said, help support and grow it. And I'm looking forward to observing your meeting today and learn a lot about what you guys do. So thanks for having me.
Hi, I'm Sharon McAlawyer, and I am local bar staff for the Los Angeles County Bar Association. And I've been on this committee since 2016. Sorry.
We got Ellie. Hi, I'm Joel Mark. I've been warming a seat on the CMFA since 1993. And I'm left today with a burning question, why it is that I've gotten older and Mr. Diefentorum hasn't aged a bit. It's impossible.
My name is John McDougall. I came on the committee in 2017. I'm retired currently. I practiced in Alameda County. I was a certified criminal law specialist for 19 years, and I started doing arbitrations through Alameda County's program in the late 90s or the early 2000s.
Hi, I'm Isabel Liu. I'm a staff attorney for the Mandatory Fee Arbitration Program and committee coordinator for the CMFA.
Great, thanks for introducing yourselves. I'd like to call the meeting to order. Isabel, do you want to do a roll call?
Sure. Okay. Okay, Ken Bacon.
Here.
Anahita Jemian. Here. George Dewsteicher. Here. Jo Beth Halper. Pat Maloney. Joel Mark.
Here.
John McDougall.
Here.
Sharon McLawyer.
Here.
Nick Migliaccio.
Here.
Clark Stone. He's not here. Lee Strauss.
Present.
Lorraine Walsh.
Here.
Roy Zuckerman.
Here.
Okay.
All right, I'd like to call for any public comment. All right, hearing none. Chair's report, that's me. Couple of things just to report. You may have heard the Contra Costa County Bar Association decided to disband their program. So that was about 2 weeks ago, and they were sort of uncertain if the mandatory fee arbitration even existed. I haven't been part of the local program, but I participate in other bar activities, so they tend to email me. And so I said, you know, the statute still exists, the program still exists, it's just the committee. So when we last met in November, and I know Randy and Andrew and Lauren weren't there, but we did have a discussion about some type of communication from the state bar as the state bar to local programs about, you know, basically the state of the union, what's going on. Because as we discussed in November, if there's no communication from the state bar, local programs tend to fill in their own reasons. And I think the communication gets very stilted. So we had asked whoever is in charge of sending something out to do that, and maybe we need to bring that forward again. On sort of a related matter, we had, I think, 5 or 6 people that applied to be on the committee this year, and I got a call yesterday from one of them wondering what happened to her application. So I think at a minimum, and I don't know who this person would be, but we need to at least extend the courtesy to those that applied to say, we no longer have a committee, thank you for applying, and thank you for your interest. This is someone that just followed up on her own. So I think those two areas are related because they concern the message to our partners and people that are interested in this committee, what's its status. So maybe we can get some feedback from Randy. I'm not quite certain of the chain of command anymore, but I think some communication needs to be sent along those lines. So that's my report. Next item on the agenda, approval of the November 2nd, 2018 meeting minutes. Is there a motion to approve as submitted? All right, is there a second?
Second.
All in favor? Aye.
Aye.
All right, staff report, Isabel?
Did you want to do the presiding arbitrator report first?
Oh, did I skip Ken? Was that on purpose? Our presiding arbitrator.
I was only going to take an hour or so. No, actually been relatively quiet. Had a couple of, removal jurisdiction ones, nothing unusual. They can't get a fair hearing with the local bar because local bar has lawyers and every lawyer knows every other lawyer, so there's obvious prejudice there. So, how's that? Okay. Other than that, I don't remember if I mentioned at the last meeting, we did have an action where a client who received a refund has now sued the state bar. What happened was they had a non-binding award for a refund. The lawyer filed the appropriate paperwork to reject that, get trial de novo on small claims court. Small claims court issued a judgment which didn't quite frankly make any sense. It said the respondent, who was the client, did not owe anything to the lawyer, which wasn't really an issue because all the fees had been paid. The underlying award had been for a refund. But the attorney did file, and then the court issued a clarification that didn't really clarify it too much, but now the client is claiming the state bar has to enforce the award, and our position was that it was de novo, and there's now a small claims judgment, there's no award to enforce. So he apparently has filed suit against the state bar, seeking to compel the state bar to start an enforcement action against the attorney. Did I sum that up correctly? Or, yeah. Other than that, that was about it. A couple of requests for payment plans, nothing too unusual. Attorneys with health problems and financial problems, but that's about it.
All right, Isabel, staff report?
Sure. Hi, all. This is Andrew again. I just wanted to provide a quick update on the State Bar's Ethics Symposium. You all may recall COPRAC extended an invitation to those on this committee, to those who are interested, to share some ideas on topics for one of their 4 panels for their symposium, which is being held on Friday, April 12th. I think it's the 12th, in Los Angeles. And we really appreciate the input. Those of you who took the time to provide ideas. It was really helpful. And just as a quick way of background, the symposium's an all-day continuing education training event. It is comprised of 4 panels. It's usually high-level ethics topics. This year, because the Committee on Professional Responsibility and Conduct will be assuming some of the roles and responsibilities of this committee next year, they decided to take on a panel focused on fees, fee agreements, arbitration. It wasn't quite specific. They just wanted to brainstorm and have some fee element as one of their programs. And they did decide upon one. It's a working title, and that title is Emerging Challenges to and creativity in fee agreements and fee structures. And this was really informed by one of the suggestions that was provided by you all. And again, working description, it's subject to massaging or change. It states, this panel will address ethical questions raised by latest trends in solving billing problems and offering and implementing alternatives to traditional bill-by-hour fee structures. Areas of emphasis will include unfinished work doctrine, hybrid fee structures, contingency and flat fees, special problems of relationships with third-party payors, including litigation financing and value billing. The discussion will cover best practices and the impact of the newly promulgated rules of professional conduct and the Supreme Court's decision in Shepard Mullen versus JM Manufacturing Company. And we would love a participant from this committee to be on the panel. And the moderator of that panel is still working through the structure, but just wanted to alert you that Isabel will be in contact, either leadership of this committee or with you all, concerning the participation of one of you all, should you be so willing, in the next couple weeks or so. And again, and everyone's, of course, invited to attend and learn from and watch the symposium, particularly those in the Los Angeles area, particularly those of you who have connections with the fee arbitration program that's run out of the Los Angeles County Bar Association or Long Beach County or any surrounding Los Angeles County programs. We would be more than happy to have those folks come and participate by watching and taking part in the symposium in that manner. Double-edged report. I wanted to thank you very much because it was really helpful, and also just to give you a heads up that Isabel will be reaching out in a couple weeks or so to try to get one of you to participate. If you have any questions about the symposium going forward, you can always contact me directly.
All right, Isabel, did you have a report?
Sure. So we have the office statistics and the schedule of events. So for the statistics, you'll see that overall the arbitration caseload is increasing. This is in large part due to the local bars that closed in 2018. That was the Tulare County Bar Association and the Monterey County fee arbitration programs. Tulare, their rules were approved in November, so they should be up and running at this point. However, with the loss of the Contra Costa County program, we anticipate absorbing their caseload. They estimated they get at least 30 cases per year, so they won't come in all at the same time, but over the course of the year, we'll see our caseload increase. And this is in addition to the lack of a program in Alameda County. But the Bar Association of San Francisco has expressed a willingness to accept any cases that would have gone to Contra Costa because if the parties stipulate to the Bar Association San Francisco's jurisdiction, they can take the case. So those cases will either go to the Bar Association San Francisco or the State Bar Program. You'll also see that the number of phone calls is really skyrocketed. We're not exactly sure why, but we're working with IT to make sure that the phone tree and everything is working properly. We had a 2,000 call increase between 2017 and 2018. So that is largely reflective of our shift to a centralized call system. And then as for enforcement cases, they've held steady. About the same number of requests were received in 2018 as we did in 2017. Most of the time the attorneys pay, so I didn't have to file as many motions, didn't have to do as many admin penalties. I do have a couple cases that I think are ready for motion, and then a couple attorneys got disbarred, so we lost jurisdiction on those matters. And then for the calendar events, we have a lot of trainings coming up. There is the Sonoma County Bar Association's training. We're loaning George out to them to do a basic fee arbitrator training. We also have 2 trainings coming up in the Los Angeles area. We have a basic and an advanced. Both of those will be held at the State Bar Office in Los Angeles. And I hope the panelists don't mind. I'm looking into having that training either webcast or recorded or both. I'm looking forwards and thinking in terms of during the time period where we're transitioning to online only training, that it might be helpful to have some trainings recorded so that we have a library of trainings that we can loan out to potential arbitrators. So during the transition period, we're covered and we can still continue to train arbitrators. So I put in a request to IT to see if that's possible to have both the basic and the advanced training in LA recorded or webcast. And then we also have training in Solano. That's also in early March. And then if you sign up for the Yuba Sutter training, I have not heard back from their bar association yet, so I'll follow up with them. And then the San Diego Advanced training, that was put on hold until after the the San Mateo County Bar Association's board meeting later this month. So they'll make a decision as to whether they want to go forward with that.
All right, turning
Lauren.
to, I'm sorry?
Under recent developments, I guess, is one of the things. I think I was going to bring a topic to the attention of everyone.
Okay.
A lawsuit that's pending. So I don't know if you guys remember a case that I actually was the arbitrator on for the LA County Bar, where the underlying matter was an IP matter. And the client felt that the fees that the attorney had charged him in connection with doing work was not authorized. So the case came before me. It was a non-binding case. After I heard the case and I agreed that the fees were not, it was basically duplicative billing and shouldn't have been charged. The law firm filed their de novo 35 days after service. So this is that case, if you guys remember, where we had a whole discussion at some point a few meetings ago about the 30 days versus the 5 days for mailing and if it applied or whatnot.
I did a memo,
Yeah.
a research memo on it.
So this case has now gone up on appeal, and I will forward the appeal brief to Isabel so she can send it around to everyone. That particular mailing issue or that issue is one of their main cruxes of their one of their arguments as to why the case.
Did they get to add on 5 days, which is not the law.
Right.
Yeah.
So that's one issue that we might be seeing some appellate court rule on here in the future.
So is that in the Second District Court of Appeal?
I'll tell you, it is.
Yeah, I was going to say we might want to do an amicus. Because the law is fairly clear. You don't get to add on.
It's in the Second Appellate District.
Yeah.
Division 5. The other issue that was raised, so what ended up happening was the thing goes de novo, and the trial court ends up awarding attorney's fees in the amount of.
It was about $200 and something thousand, and they were asking, and it was reduced to 80,000, I believe.
Yeah.
Something like that.
So there's like
80,000.
all these attorney's fees. So
Judge
another
Stewart.
issue that is at play in this is whether the folks that represented the law firm, which were part of the law firm, should have been awarded attorney's fees or not. So it's a side issue. It doesn't really have
So
anything
did the
to do with
attorney's
us.
fees come in on the motion to enforce, or were they in the original fee arb?
So all the attorney's fees that took place in the trial, so they had a trial, they went to trial on whether the attorney's fees were just or proper or not. And they were found that they should have been, that the trial court found against me,
Not against you, but against the award.
Right. The trial court decided that it wasn't duplicative billing, and that the client, even though the client told him not to render any more services, that because he didn't put it in writing, that the services that were rendered he should have paid for. On top of the $4,500, that's what it was, I think, or $3,000.
It was $4,000, the amount in dispute.
Right.
You gave them like $2.56.
I did.
Yeah, and then Judge Stewart awarded them the 200 and whatever, the 80,000. And the issue is the 31 days, and the second issue is whether they were in pro per.
Right.
Oh, and entitled to the
Entitled to
trope
the attorney's
case, yeah.
fees. And this particular lawsuit, or this particular law firm, was involved in another lawsuit that went up on appeal where they also were told, no, you can't have attorneys that are working for you, claim they're, outside counsel or independent contractors, and they've already been knocked down once on this issue. So it's kind of two separate issues. That one's not really our thing, but this mailing, whether the 5 days applies or not, could be something that could.
Maybe we
could
can
come
get
up
the
for us.
case, because I'd like to follow it. I don't know where they're at the briefing stage, but
It
the
just-
the
like, I
docket
just-
would show us.
What
just filed the
happened?
appellate
They just
brief.
filed it because
An opening brief.
the client keeps emailing me saying, hey, like, just want to let you know, like, what's happening, and kind of keeps me up to date as to, like, what's going on. I don't really reply, but I did ask him to forward me the brief, and it was filed on January 10th. So
But
it's,
he reads the emails with enthusiasm.
well, so
And then he
anyway,
sends them to me.
I'm going to forward this to you, Isabel, so you can send it to everybody. So it just might be something we just want to follow this case. And if we want to write something if we do want to write something about this,
Yeah, I mean, there's the avenue of the amicus brief in, Court of Appeal cases, but because we're in this transition phase, I don't know what approval we would have to get and from whom to do an amicus, because as we learned with, at least the last case was Baxter versus Bach, the parties did not submit what we considered the correct law to the Court of Appeal on disclosures. And, you don't get good briefing, you get bad results. And so, to me, and I think Ken weighed in on that, the law is clear, you don't add 5 days. So they would have had no right to de novo it. So it's sort of the house of cards goes back, and I guess we can work through Isabel to see if there's a possibility that we could file an amicus brief if the parties don't cite the right law. Because I remember you brought this up, Lee, and they had some strange rule that they gave to the trial court or something on the mailing, and they didn't find the right
remember all
I know,
cases.
because in ACMAS, at LA County Bar, we debated it as well, because it was of concern to us as well. I can't remember how we came out on that subject, but
Okay,
we were
well,
just waiting to see what the court of, we understood that it was gonna work its way up. But Isabel will find out for us.
yeah, if we can submit an amicus, if that's,
Yeah, I think in the past, there had to be board approval for letters for the.
Yeah, we
so
did a,
something similar to that.
yeah,
so.
in Baxter versus Bach, we did a request to decertify that opinion, and we did have to go to the Board of Trustees to get approval, which we did. So I don't know if that path is still available to us, but it's worth exploring because it affects every case that's non-binding, and there's a right to de novo. And people always claim, oh, I get 5 more days for mailing. They seem to think that that's the consensus, but the research is just the opposite. When you have an appeal, you don't get the benefit of that, and there's cases that say that.
Well, in the brief, they say the trial court ruled that the summons and complaint were timely. It reasoned that because the arbitration award was served by mail, the 30-day limit was extended by 5 days for mail service, and they seemed to rely on Civil Code Procedure 1013, and they say this was error. And they then go on to cite, you'll see, which is 6204, saying that within 30 days.
You don't get the mailing. Anyway, there's a case that deals with it, and if no one cited it, my feeling is that the Court of Appeal needs the correct law. And it does affect, all cases where there's non-binding and a right to de novo. So, all right, well, thanks for bringing that to our attention, Lee.
Yep.
All right, under business, I'd like to move item 7 up to the top, and that's the discuss the proposed change to the Los Angeles County Bar Association rules of procedure. They actually sent the request to me. They want to change the rule that allows a mediator to charge for his or her time, or I'm sorry, an arbitrator to charge for his or her time after 4 hours. And the proposed change is in your board packet. I asked Isabel to gather some information from surrounding bars as to charges, and that was handed out this morning if you didn't get it. So there's the state bar and the model rule, Long Beach, Santa Monica, San Fernando, and Orange and San Diego. And it looks like the proposed change of 175 after 4 hours is in the ballpark. So Sharon, did you want to?
No, it's above the ballpark.
Anyway, did you want to add anything on this?
The only thing is that the rule change will bring it more in line with what everyone else is doing in regards to compensation, because at the LA County Bar, the rule has been for over 20 years that arbitrator doesn't receive compensation till after the second full day. So we're just trying to make it more in line with what the other programs allow for arbitrator compensation.
That's a non-fee arb program, or through LA County Bar, or?
No, this is the mandatory.
Mandatory fee arbitration.
Well, I know, but what in line with what other program?
With the other programs like the Beverly Hills Bar, the State Bar of California allows arbitrator compensation after 4 hours.
Yeah.
But the LA County Bar hasn't been, doesn't have the same rule. For many years it was after 2 days, then they were paid like $400 for a day shared by the parties for each person. But now they want to change it because more of the cases, we're seeing more cases that require panels to do the work. And so, and they're going beyond that time. They're having to put in more time. And so basically a lot of the arbitrators that would spend time on these, they don't want to do it if there's a lot of money involved, because they have to spend a lot of more time writing the arbitration awards and handling the hearings. So we just want to change it so that they could receive some compensation after 4 hours.
All right, any other discussion?
It's
Only for hearing, no, not for preparation.
Right, it's not for prep, it's not for award drafting, it's not for circulation if there's a panel. It's just for the hearing time. And, LA County Bar has been grappling for a while with competent arbitrators and how to get them and keep them. We just think that this is going to hopefully help that situation as well. Because we've been having some issues with awards that are, for lack of a better term, poorly drafted. And so, this is just another attempt at LA County Bar to try to get better arbitrators, since we really don't have any other ability. If you have a pulse, we can use you until we see your work product. So anyway.
Any other discussion? Andrew?
I just had a question, if it was available. Do we have data or information on the hourly rate other local county bars charge when
Yeah,
the hourly rate kicks in?
we had a handout that wasn't available at the time. the board packet went out, so I don't know if
Should
it's
be
sitting
there.
down around
Yeah,
your
there's
area.
Extra copies down there.
Yeah.
Yeah.
Just to put in the record, the state bar, and we'll get to you, Ken, patience. The state bar and several local bars have adopted the 150 after 4 hours. Long Beach has no compensation. Santa Monica has less than 10,000, 150, greater than 10,000, 150, and differing hours. San Fernando, 250, Orange, and
No, San Fernando, it's $250 for a half day, not per hour.
okay. I'm highlighting sort of the hourly here without repeating. Orange, 4 hours, 200, half day. San Diego, 150 per hour over 3 hours. So that's the surrounding areas, Andrew. So Ken and then Joel.
Yeah, two issues. I don't think any program has been approved above 150. That's the standard that's been approved in the past.
Well, that's not on the table for today. So
well-
we're not going to revisit what other people are charging.
Well, it is on the table because we had this issue a couple years ago about whether there's even jurisdiction or it's appropriate to have these hourly fees. When this was last visited, I know Doug consulted with general counsel here, and I don't know, can we discuss that in public, or do we have to go off the record with the general counsel's position?
Well, today, I think, we have a difference of opinion. Today, we're just ruling on or deciding on LACPA's request. I don't think we can revisit other counties that have developed other rules that we may or may not have approved. Because it's not on our agenda, Ken. I understand your point, but it's not on our agenda to look at what other people have charged.
It is on the agenda because what general counsel opined was that the authorization in 6200 to charge a filing fee does not authorize the $150 per hour fee for arbitrators. So what has been approved arguably is in contrast to the statute. So that's the basic underlying issue.
And maybe we have to bring that to the agenda for May because I'm going to make a.
Can I finish?
No, I don't want to talk about something that's not on our agenda. And
the propriety of the fee is on the agenda.
Right, but not all what these other groups are charging.
I'm not talking about what other groups are charging.
All right.
I'm talking about the opinion we as a committee got from general counsel about the propriety of this $150 per hour fee. My position would be that's a question, but since we've authorized that for other programs, I suppose we can do that. I'm a little bothered by increasing it above the 150 because once we open that door, then other counties are going to start talking about increasing their fee, and it gets this whole issue about this being a speedy and cost-effective process. And once we start increasing those fees, I think that undermines the overall goal of the statute. So.
Yeah, personally, I am opposed to charging any fee, but that's my opinion here today. Joel, did you want to add anything?
Yeah. First of all, statement of bias. I agree with charging anything is contrary, I think, to the spirit of the program. And it also can work a surprise on unwitting clients where they get to the end of the 4 hours, they have something important to say, and all of a sudden they're going to, I didn't know I was going to have to pay $150 an hour to be able to say it. I don't like it. Having said that, if we're going to go this route and answering one of the problems that LA has had for years is can we make arbitrators who do invoke this or go the more than 4 hours and accept the compensation accountable in some way to some kind of stricter oversight, including potential review of awards before they go out, you know, ultimately kicking them off the panel if they don't do right, don't get their awards in on time, that kind of thing. Is there anything that prohibits LA, at someone's urging, if it's ours, great, from having some kind of quality control element if they take the compensation?
Anahid?
Well, we already have a quality control system in place. We have vice chairs on all of the arbitrations, and the vice chairs do review the awards for compliance with the law. And we do have the option, which is exercised by some of the vice chairs greater than others, to remove an arbitrator from the panel if he or she consistently is not following the law or is rendering opinions that we feel are not the best to further the cause of the program itself. So, but the issue of whether initially any sort of compensation is appropriate could be put on another agenda, the next agenda. Right now, the only thing the LA County Bar is asking, and yes, I have a bias, it's the bar I belong to, but it's just asking for the same sort of compensation within the ballpark, because, you know, Ken's correct, it's 150, we're asking for 175, or it's asking for 175, but so far, that's been okay to ask for compensation. So we're just asking for that, and how the arbitrators or the program then enforces the payments is a different thing. And to speak to your initial issue that, you know, a party may be caught unawares, no, it's not at 4 hours some arbitrator is going to say, okay, now I'm just going to start, you know, charging.
But
The
the
parties
actual
are
law?
notified ahead of time, just like
The
they're
actual
notified about everything having to do with the procedure.
No, I don't
that
have it
they're
all.
going
Is it
to
that
embark
simple?
on,
154 hours?
They're going to have to pay.
Yeah, per hour.
And Lee mentioned something, it might encourage some of the parties, not just the lay parties, but the attorney parties as well, to be concise and to be brief, to not be all over the place, to actually address the issue so that it's a shorter arbitration, so they don't have to pay.
If I could respond, number one, we've had, the LA program has had that vice chair stuff since I was running the program, and it was hit and miss at best, and I thought maybe this was a chance, as long as we're reviewing this concept, to add something to it. Second of all, it's never encouraged anybody to be concise at all, as far as my experience has been. And in fact, you actually have this subliminal, and no arbitrator will admit it, but you have this subliminal, you know, if you want more time, of course you can have it because I'll get paid. So I'm not sure it works just the way it's intended.
Roy and then John?
I think we need to understand as we're talking about this, that we're not talking about $175 an hour. We may be talking about $525 an hour, because in most cases that go over 4 hours, you're talking about a panel, not an individual.
Yeah.
And so we're talking about $525, and I think we need to bear that in mind. When
Yeah,
considering
I think again, if we want to send this back to LA, I think we have to, because there has to be some specification. If it's a single arbitrator, X amount, 3-person panel, X amount, because I don't think a 3-person panel is going to split 175. So that's not specified. I think there's an undercurrent that I'm hearing, that the members want to revisit this issue on compensation. There is the general counsel opinion, but we do have a model rule which allows it. So if we want to revisit this issue of, do we even want compensation, I think it has to be on an agenda, and maybe we add that on May. But right now before us is the LACPA request for 175, and if we don't feel we can approve that now, that we need some modification, maybe we conclude the discussion, get everybody's opinions out, and then put it over to May. Hanheed?
Just to clarify, the proposed rule does in fact state that it's per arbitrator. It's not that it specifically says should be paid equally to each party, directly to each arbitrator. And it says no compensation will be paid to arbitrators for services. So it does specify that it's per arbitrator. It's not $175 if one arbitrator, $175 if it's three arbitrators. So at least.
Yeah, I see the plural, but maybe some language needs to be single versus, excuse me, a three-panel.
But does that coincide with the other? Because I don't know how we can justify telling LACPA that you're doing the same thing as other people, but we want.
No, we're just having a discussion about, the parameters of what can be charged. We're not saying you have to do this. We're just having a discussion right now. John?
So a number of bar associations are already doing this, so I assume that there's experience available about how to administer this. The rule in the material says paid in advance to the arbitrators, and I'm just wondering, I haven't encountered anything like this in my experience. I mean, are the parties put on notice, you better bring your checkbook? When they get to 4 hours, do they say, okay, we're stopping until we get these payments that the rule allows for? And I'm assuming that the rules in these other bar associations that are already doing this are at least similar to what LACPA is. And then if it's not, does that actually cause a halt in the proceedings if the parties can't produce a check payable to the arbitrator? Maybe somebody has had experience with that and would speak to that.
Lee?
Okay. I appreciate all of this discussion about how it would work, but quite frankly, that is irrelevant because I'm the one who proposed this rule change at LACMA. I'm the one who researched the whole thing that Isabel did. In fact, I just found it when I was cleaning out my office the other day. And all of these rules, this is a very abbreviated version. All of these rules are exactly like the rule that is being proposed. The only thing that's different is potentially, for the ones that are paid by hour per arbitrator, is the 175 versus San Diego. It's 3 hours and 150, and the other ones, all these other ones, Beverly Hills, are 150 over 4 hours. So how it's administered and what happens in the local program is not for discussion because it's irrelevant. It's, are we prepared to approve, yes or no, the rule change just like all these other programs have? Because if we're not, then someone here needs to give the three of us the information to take back on Monday when we have our meeting as to why it wasn't approved and what will get it approved.
Okay.
So that's my take on it.
Andrew?
Just by way of observation, you can see other programs do use $150 after 4 hours. However, I don't see any other program that uses $175 per hour, and I think it might help inform the committee if they request from Los Angeles County the justification for $175 as opposed to $150. That might help you make an informed decision as to the distinction between $175 and $150, because it does appear $150 has been acceptable previously, but for the first time, we're now going to $175, and I think we're lacking that information as to why they need $175 as others only
And the
require
way the model
$150.
rules work is if there's if a rule change conforms with the model rules, we pretty much approve it. But if it differs, then we do need some backup. So in this case, the model rule says 150, which other surrounding counties have adopted. So, maybe Lee, you can,
Well, San Diego's rule that was approved by this committee completely goes against what you're saying, Andrew, because it's after 3 hours is 150. So an additional hour is being charged as opposed to starting at 4 hours. So if you try to start looking at the comparisons, San Diego's actually charging potentially more.
I have a procedural question. Can we approve this, or do we recommend to the board that it be approved?
in the past, we approve rule changes.
It goes up to.
And then whatever we recommend, it goes to the Board of Trustees.
Then I have a motion.
All right.
I move that we approve this request with the caveat that we are going to review the entire question of compensation and that the approval is pending a final decision.
All right, is there a second?
Well,
I don't know, I don't know if this committee's gonna be around in order to make that determination, or if it can be assumed, subsumed.
We have a meeting in May and we have a meeting in June.
Right.
The
I
other
always
thing to
assume I'll
keep-
be alive tomorrow, so let's assume there's going to be.
The other thing to
another-
keep in mind is the 150, if we probably went back and historically looked at when that 150 rate was put into effect, I bet it was 10 years ago, plus at some period of time. It's how about cost of living? It's 175 is a more appropriate rate if I'm sitting there after 4 hours. I mean, Sharon's right. It's they call me and they're like, hey, do you want to take this case? It's $500,000 or $600,000, $1 million in dispute. I'm like, no, I'm not doing it because I don't have I don't have the time. Two, it's I'm not going to sit for 2 days and listen to all of this potentially, or 3 or 4, and not know that there's a relief, at least compensation wise. So I don't think the 175 is out of bounds at all, especially if you look at it in light of what San Diego has already been approved to charge. It's $25. So it's what, we're talking $75 for 3 people?
So right now, we have a motion from Roy to approve it with a caveat that we're going to revisit whether or not compensation should even exist at our next meeting. So is there a second on that?
No,
I
is
can
it?
second that.
I just wanted to clarify, that means that we will place on the agenda the broader issue.
Exactly.
At the
That's how
next
I
meeting.
understand it, Roy.
Okay, and for Lee's benefit, I'm against compensation, but I will agree that 175 today versus 150 a decade ago is meaningless. So,
Move to approve the rule change.
Okay, we have Roy's motion on. I think Anahit said a second. I just want to be procedurally correct here.
Yeah, because that's where we're
So,
at
so
anyway.
any other discussion on what's on the table right now?
So would that mean that the portion that approves the 175
Well,
would go forward?
We'll have a vote on LACBA's request for 175. On our May agenda, we will revisit the issue of compensation. That's what's on the table right now,
For all
For
of
all
for
bars.
everybody.
Could I propose that that's really 2 motions?
Yeah, I agree.
Okay.
I
We
agree.
split it up.
Yes.
Because
We're either approving this or not approving it. And
All
then
right,
we're
so
gonna talk about whatever we're gonna do in the future.
I'm gonna split it into 2. First is approve LACBA 175. Second is revisit the issue of compensation at the May meeting. All right, so any other discussion?
well, yeah, I think to do those in reverse, because it's possible that some people may view getting that on the agenda as the more important thing and might affect their vote on the other issue. Just switch them, that's all.
All right, so raise your hand if you want to put the issue of compensation on the May agenda.
Do we have a May meeting, or is that was June?
No, we have a May meeting in LA.
All right, so that's unanimous.
All right.
Yes, on May.
Yeah.
All right, so unanimous. Second motion to approve LACBA's request to change their rule. I believe it's 42, 175 compensation over 4 hours Everyone raise your hand if you want to approve.
Can I vote?
Yeah, you can vote.
Okay.
Sharon.
It's just your salary, come on.
So we have 3 names, right? Migliaccio, Mark, and Bacon, is that right?
I'm a no.
Mark,
Okay.
right? Yeah, and Bacon, okay, so there are 11 people here, so we have 8 yeas, 3 nays.
So it's approved. All right.
I'm sorry, just, I am curious, and this might be relevant. There are 3 folks who participate in the LA County program at the table?
Right, Sharon, Anahid, and Lee.
Okay, thank you.
Because we're a big bar. We need several people.
Yeah.
All right, moving right along, going back to line item 1, under business, finalize updated sample fee agreement documents. That's me and Ken. First of all, is there any questions on any of the materials?
Excuse me, where are we? I'm sorry.
We're on D, business, 1.
D1, got it, thanks.
D is in David.
Thank you.
So in the sample fee agreements, this is sort of a quick overview. Since the rule change, we changed all the rules from the old rule to the new rule. Substantively, there were some changes to the flat fee, and Ken, chime in if I'm missing anything. Then we have the mediation notice and acknowledgement form that's been added. On the instructions, my suggestion was to add it at the end where it lists disclosure forms. Ken thought it should be in the paragraph that dealt with mediation. So that's something that we need to decide.
Where is it in these materials, Lorraine?
I don't know the page numbers, Joel. You have to look at the agenda.
30, thank you. Sorry. Thanks.
Again, going back, any questions or comments, discussion?
Well, yeah, just for Joel, because it's not clear, because these aren't red line. There's a discussion about mediation in the instructions. That's on page 12. And my thought was, in this instructions regarding the optional clause, we might want to. Okay,
A little
we
bit
did
louder,
add that
Ken,
one already.
please.
Okay.
Ken, a little louder.
Oh, I'm sorry, yeah, I'm sorry, it looks like we did have that in this draft. Because that was the discussion we had in the background, was we should put something in the instructions about the fact that there's this optional clause, but it looks like, I guess we do have that in the final draft.
Yeah, and again, just repeating, my suggestion is that it come under disclosure forms, which is page 14 going over to 15, to coincide with the third-party payor form and the joint rep form. And my suggestion actually has the text of Evidence Code 1129 that says you're required to have a form, that it has to be on one page, that you can't attach any other document to it, that has to be the 12-point font in the client's preferred language, and of course have the signatures of the parties. So I think my suggestion is it fits in better on disclosure forms. Ken thought it should be up in mediation clause, and it really isn't a mediation clause. It's a disclosure and notice to your client if you're going to participate in mediation. So I think it makes more sense on the back end.
Yeah, I mean, what I added, and I see it is in there on page 12, where it says the mediation clause is optional. And the language I added, however, if it's used, beware that per 1129 requires the disclosure. And then we have the actual disclosure part later on page 15. So I think having both is fine, and puts it in the instruction, and then it has it under the disclosure.
Yeah, you could leave it in both, yeah. All right, Nobody has any questions or comments or suggestions?
Could you
Clark?
point us to the optional mediation clause on what page that's on?
So, optional is on page 12. And there's a paragraph 2.
Yeah, I see that, but I.
No, the
And
actual
then-
clause
and the
on page
act-
46.
Excuse me.
46? Okay, I see that. Thank you.
It's taken straight from the statute.
Yeah, the statute has language that basically is the form.
Okay.
All right, so I'm not hearing any questions or comments, so is there a motion to approve the updated sample fee agreements and disclosure form, leaving the instructions, having it in 2 places?
I'm sorry to interrupt. I do have a question about flat fee if we're done with the mediation
Oh,
question.
sure.
So I'm looking at page 38. I don't think I have a red line. I know Ken referenced a red line. I'm only bringing that up in case my pages are different. Page numbers are different than the ones you're looking at. Is this the only place where the flat fee discussion occurs?
It's also on page 13.
Well, there's a discussion about, I think there was a discussion in the instructions, isn't there?
Right.
Right.
I do see that paragraph 7.
So the way that Ken and I worked on these forms, I think it was 2015. So we have the actual paragraph in the sample fee agreement and then standalone instructions for attorneys how to use it if you want. So
Okay.
it will be in 2 places all the time.
Okay.
Because we're suggesting language and then we're telling attorneys, if you use it, these are the key points, this is the law that applies, that type of thing.
Okay. And I'm only asking to make sure, I'm going to have questions on page 38. I just want to make sure that would be the only place that the flat fee is referenced outside of what you just told me on the instruction page.
Yeah.
I'm going back and looking, actually, I'm not sure if it's discussed in the instructions.
So I have a conceptual question and then suggested edits within the language.
Okay.
And conceptually, I talked with Randy and Isabel about this. I wonder if this could be broken up into 3 parts, because there are those attorneys who take flat fees and comply with the rule and deposit them in the client trust account and don't require written disclosure, nor is it over $1,000 and require written consent from the client. There's a second group. It's under $1,000. It just requires written disclosure.
Right, and Andrew, if you look down in the last paragraph, there's the second option where if it exceeds the 1,000, that the client can make an election, basically. So there's
Sure.
maybe we can maybe it's a word processing thing that we could highlight that it's an option within the flat fee.
Well, what we did, Andrew, because it's similar when we had before, when we had the model fee agreement forms regarding advance fee deposits, even when the law was unclear, the form we used, we did as a best practice is that even, so it goes into the trust account.
Sure.
Even though under the law it didn't really require that. What we did here is in that second paragraph, we just have this set up as essentially a best practice. If you get a flat fee, put it in the trust account. And then we provided the option where if somebody doesn't want to do that, I mean, 'cause once again, this is a form, but we kind of had it as a best practice. If you're getting a flat fee, put it in the trust account.
Right, which arguably is required now under the rule. It's not.
It could, in some cases it's not, but it's, the default is, the way we drafted this was put it in the trust account. And if you want to do something different, then you can use the option or you change the form, because once again, it is a form. But just the default, put it in the trust account.
So maybe where it says option here, we can maybe beef that up with a little more language or highlight it to say basically what Ken just said.
Well, let me phrase it a different way. So I recognize that last paragraph, option where flat fee exceeds. You know, we could quibble over the language of option, but I mean, I think it conveys what is necessary in that circumstance. I don't have a problem with that. But the 3 paragraphs above, I think that we think that that could be broken up into 2 examples. One in which you're depositing in the client trust account until earned, and then the other, which would require written disclosure because it's less than $1,000. There's no consent required, which in the second paragraph, unless the client consents in writing, that arguably isn't the requirement when it's under $1,000.
So without seeing alternate language, it's hard to conceptualize. Maybe
What I'm
know,
hearing is, and if I'm hearing you right, I kind of agree, is that we're really letting the tail wag the dog here, where we ought to write the rule just assuming it exceeds $1,000, and then have an asterisk or some other optional where it doesn't. You don't have to put this in. Is that sort of what we're saying?
Well, that is an option. I guess what I'm saying is it's not. And I mean, I think these are great. I'm not being critical at all. I'm just trying to be helpful.
We're just
I just think I think it's less clear what's applicable when. And I don't know if a subheading could break it up.
Well, the only thing, one thing I would comment, at least when we were talking, it was my understanding this option clause would be under the optional clauses, not in the actual agreement itself. Because I do think that might get a little confusing. So you would have this option where it exceeds 1,000 in the optional clauses like we have all the other optional clauses. It's under the agreement. Page 38.
I don't think that's where it should be.
Yeah.
Oh, okay. I thought we were looking at the actual fee agreement. Okay, my bad.
Yeah.
I mean, yeah, so flat fees paid in advance must go in the client trust account unless these exceptions are present, right? Under the new rule.
Yes. And rather than deal with all the little minutiae exceptions, we just decided kind of as a best practice is put it in the trust account.
I'd
If
agree.
you don't like the optional clause, you're free to ignore it and use some other clause, but
Right, just a
I think
suggestion.
it's just kind of encouraging putting it in the trust account, whether it's absolutely required or not. Kind of a best practices approach.
And so on the, where the options exist, there's less than $1,000 written disclosure, over $1,000 written disclosure and client consent.
Right.
And again, I might be an uninitiated reader. You guys have worked with these for many years. You know how it works and what they're referring to. I just worry about the new practitioner who might be less clear in understanding how they're going to implement these.
Anahid?
Can we have something in the introductory section that specifies that for emergencies and corporations, written fee agreements are not required, and then still address the issue of what you need to do?
Well, we're on flat fee right now, so maybe we can,
That's right. No, I'm saying like, okay, if you're gonna get a flat fee, but it's an emergency, you still have to do certain things. I don't know if that's also helpful in the introductory section. Because, the way it's set up is, speaking to Andrew's, concern, a new practitioner, he or she may think, written agreements are required in every situation, and that's not the law. And so when they're not addressing written fee agreements, they still need to comply with the law. Is there something that we perhaps need to put in the introductory section?
well, right now it's in optional clauses, and the reason it's an option, it's not an hourly, it's not a contingent fee. Those are sort of the basic types of fee agreements. For criminal lawyers use flat fees a lot. Probate, trust litigation that, you know, a flat fee for preparation of a trust. So it's not the you know, it's not the normal fee agreement, so that's why it's an option if you want to use it. And then the new rule tweaked it with this exceeding $1,000.
I understand, maybe I'm not being clear.
Yeah.
I do understand that we're talking about written fee agreements, but there could be a flat fee agreement that is not written. Because the client needs something tomorrow, and you're not, you know, he or she's on the phone, and you're not required in an emergency to have it. You're not required if you're a corporation to have it. So, you know, the same sort of law still applies though, but it's not in writing. And so I'm just saying, maybe we need to address that, and you're correct. I apologize, maybe I'm asking it at the wrong stage, but I'm just throwing that out.
Well, I think it was when you were off the committee.
I'm often off.
In between your stints, the last time we
Not physically here.
the last time we redid these, there was kind of a simplification on the instructions. And, you know, I think, you know, the exceptions and stuff that are in 6148 and all that, we didn't go into all the minute details of the statute. We just kind of, it cites the statute, it cites the basic rules, you know, and lawyers can look that up or not look it up. We always encourage them to have written fee agreements, whether it's required or not, and they can figure that out on their own. But I think we took that out when we simplified the instructions.
I think every lawyer, especially now, you know, they reiterated the law that, you know, you're independent of your boss. You can't say, you know, he or she told me to do it. But I'm just saying that just to be accurate, maybe that should be.
It's actually, Isabel found it. It's in the opening instructions.
The intro of the instructions.
Right, which,
I didn't see it.
Yeah, it's not
I don't see
required
so well.
when services are rendered in emergency to avoid prejudice, client's corporation, et cetera, et cetera. So basically, G&T. It's
All right, I don't see it, but.
Where is
what
it?
page would that
page
be?
6, on the very first page of the instructions,
Okay. But I thought I read that somewhere.
under non-contingent fee agreements, 6148.
so Andrew, maybe at, I always like to see
good, we did
alternative
that.
language if we're gonna change the flat fee. So maybe if you had time at lunch, I don't know if it'd be easy to like word process it a little bit, and so we could actually, after we come back from lunch, have discussion on what you believe would be some better alternative language.
Sure. I had another question,
Okay.
if you'll permit me. I apologize for taking time, but I had a little bit of concern. The first paragraph, the third line, I'm starting on the second line. This fee is fixed and constitute complete payment for the performance of services under this
where are you again?
He's on flat fees still, so.
flat fees, first paragraph, under this agreement, and does not depend on the amount of work performed or the results obtained. And I was just a little bit concerned about the phrase, or results obtained. I recognize the definition of flat fee states, does not depend on the amount of work ultimately involved. I imagine if it would be better to end the sentence after that amendment, because I fear results obtained could be troublesome if the work is ultimately not completed. Client disputes, hey, you didn't earn the entirety of the flat fee, and the lawyer could turn around and say, well, you agreed.
Yeah, I
Now,
got a bad result, you still owe it or something.
Again, you all may be way more well-versed in fee arbitration case law than me, and I totally concede that. Again, risk management, client protective, I just wonder if it might be agreeable to the group to remove the phrase, the results obtained. Or I'd be curious as what's intended by that, because if you're contracting for a service and you don't get those results, I assume results obtained means we might lose. We might lose.
Exculpation,
I
you know,
understand
I
that.
can do anything I, excuse me, want, and, you know, but, you know, this is something that Ken drafted, and I suspect that this was in the sample form fee agreements that we had previously, so.
That part was,
Starts,
yeah.
in case law. It typically refers to a criminal attorney.
Win or lose.
Yeah,
That's right.
You're not guaranteeing an
That's right.
acquittal.
Absolutely.
The fact that you get convicted and sentenced to jail is not indicative of whether or not that flat fee is earned.
Sure.
And that's typically what, John and I sat on a criminal panel, and he just had one as a single arbitrator, and I think that is the argument that's brought up.
You also have,
You pled me out, and you guaranteed you take me to trial,
on the civil side, UDs are often flat fees,
Yeah.
lawful detainers, and whether or not the person got to stay or got evicted is not determinative of whether the services were rendered.
So Clark and then Ken?
Yeah, I think that's exactly right. When you're talking about the results obtained, you're not talking about completing the work. You're talking about the results of the work. So I think when you say, I pay you this amount of money for you to do this work, but my payment is not contingent upon what happens after the completion of the work. And I think that clause, from that standpoint, is perfectly acceptable.
I was gonna say, I think that is a holdover from the old form that we had.
It is.
But as I'm reading the new rule, which defines flat fee, there's a fixed amount that constitutes payment for the performance of described service regardless of the amount of work ultimately involved, and which may be paid whole in advance. So it doesn't have anything in the actual definition about results. In hindsight, I don't think we need that in there.
Yeah.
I think, I kind of agree with Mark, maybe we just delete "or the results obtained," because that does kind of open,
Andrew.
excuse me, Andrew.
Not the dad.
Where's that come-
Disagree.
Wrong tough, sorry.
I think a criminal practitioner would agree, a defense attorney would disagree.
Well, but they can make that agreement or disagreement without the language. I don't think we necessarily need to have in there that the results obtained in the fee agreement, or at least in the base form. If they want to add that in theirs, that's fine. But from a best practices standpoint, once again, it does kind of vary from the new rule and the definition, and I don't know that it needs to be in there. It's something we're adding above and beyond the rule. Lawyers are always free to modify and encouraged to modify the forms as they see fit.
I think it creates, as Andrew said, sort of an issue which doesn't have to be created, So, Anahid?
Yeah, that language I don't think is necessary. You can have, and I'm sure most attorneys, well, I shouldn't say that. I mean, I would think it's best practice to have in your fee agreement that, results aren't guaranteed, but it doesn't have to be part of the flat fee, optional clause. It can be contained within your retainer agreement.
No, that's in the hourly sample fee agreement, no guarantee,
That's what I'm saying. So
Which is
I
it's the
don't
same
think that
concept.
That
Yeah.
additional language or the results obtained need to be in there in what we are saying is best practice to a practitioner, to include in his or her retainer.
Okay, is there a consensus that we put a period after work performed and delete "or the results obtained"? Okay, I don't think we need a vote on that, do we? All right, so great suggestion. We'll put a period after performed.
Okay, thanks. I'll try to draft something and get it back to you early afternoon.
Great, thank you. All right, any other questions or discussions on the sample fee agreements and the mediation disclosure form? All right, we'll have a vote on that.
I did have one comment as I was going through this. On page 44. The last paragraph starts with number 4.
I'm sorry, where are you?
Page 44, the joint
Joint-
multiple client, the last paragraph, number 4. The last sentence says, "The party or parties are entitled to a copy of client papers capitalized as defined in Rule 1.16E1. They actually changed that in the rule. It doesn't say client papers anymore. It says materials and property. So client papers has been taken out of the definition, so we need to conform with what the rule says, which says copy of, I think it says client materials and paper. No, excuse me, materials and property, 1.16. Client materials and property is what they call it now. So
Okay.
it should say materials and property instead of client papers.
And is that the right E1?
E1, yeah, the citation of the rule is correct. It's just that they changed the language. It doesn't say papers anymore.
All right, so is there consensus that we change papers to materials and property? All right, that'll be changed. Any other comments? All right, we'll have a formal vote on approval of the sample form agreements after we receive Andrew's suggested changes to the language in the flat fee. All right. So let's move on to item 2, discuss how to best update arbitration advisories. It says me and Roy, but I think this was asked to be added by Isabel, so maybe Isabel can explain the request to update all the arbitration advisories.
This kind of came back after the joint meeting in December with COPRAC because COPRAC does
A little
not.
bit louder, please.
Sorry. So COPRAC does not update their ethics opinions when the rules numbering changes. So we had a couple ideas of how to update the old rules that are mentioned in here. So one idea that we had was to just put a general disclaimer on them. Or we could go through and change the rule references in the advisories, but sometimes that would result in substantive changes, so we're not sure then we have to get it reapproved or we have to renumber it. And then now the arbitration advisories have to go before the board for board approval before they can be published, and public comment also before board approval. So I just want to bring this back for discussion, how you think we should best update these. Do we put a disclaimer that, the rules of professional conduct have been updated? Check the authorities before or keep that in mind when you're reading these advisories. And then what we can do when COPRAC includes members with fee arbitration experience is have those most affected arbitration advisories redone then. As one of the first assignments.
I don't trust the specific attorneys that we're dealing with in this situation. I don't trust them to go look at the rules and see what change was made. I think we need to tell them right in the advisory.
So you don't think a disclaimer would be enough? You would want to go in...
Because the problem attorneys are not to be trusted to follow through.
Okay.
Anahid, I'm just going to go around as I see hands coming up.
To me, it's not an issue of trust. The advisors are designed to assist the practitioner. And if he or she is going to be assisted by them, we want them to be easily, a resource where they can just go to that. Obviously, if they want to then look at the case law or the specific rules, they can do that. But if they only have time or inclination to just look at that, we want it to be a definitive response to them as to what they need to do in a particular situation that is addressed by that particular advisory. So I would not want to have just a disclaimer, but to actually go in and have all the rules changed. It may affect it substantively, but we can address that as necessary.
All right, Ken, and then Clark.
Yeah, I think that's essentially what I was going to say. These are arbitration advisories designed for the arbitrators, unlike the ethics opinions, which are attorneys as a whole. So we want to make it as easy as possible for the arbitrators. So if they got to go here, then there to get it. So I would say put it in the body.
Okay.
Clark,
I
and then
wanted to
Joel.
back up a bit and get an idea of the scope of work.
It's big because I printed off this for LA and
Well,
then we got it here today and there's like 50 of them,
Well, I'm
so.
trying to figure out how many advisories are effective and would either require, or would require a rewrite.
I think I counted them for the LA meeting.
Yeah, I think we did, actually,
And I,
if I remember.
and I
correctly.
thought there was like 50, 49 or 50, and they're right here. There's
But they don't
40
all need,
Well,
they
this
don't
is the
all
index.
refer to rules.
This doesn't tell me that everyone has a citation to
Yeah.
the rules. of
No,
professional conduct.
exactly.
If
And
you
so-
look
so-
on page 48, Roy's summary I brought back because I thought it was helpful. He combed through all the advisories. He said there were 42 issued since 1992. 12 have been
All right, let me look at
superseded.
that if I can, please.
Okay, and then
So
27
what-
do not
what-
reference
the page-
rules.
The page number? on that?
Attachment page 48.
27 of
48, there's only
42
three,
make no
that
reference to
cite
any
the-
specific rule. And three advisories, in three advisories, with one exception, the provision's identical. Okay, so it looks like,
So I've included those three advisories that Roy pointed out.
And if I would, I could add to that, it's not that big a project. When I was going through the materials, I went through these three advisories.
that's what I'm
It took me
asking.
maybe, and I've got it here,
That's what I'm asking.
it took me maybe a half an hour to do the edits that are substantive, other than just changing the reference to the rules.
Okay.
So how many advisories would need to be updated to reflect new rules? Total?
Two that the only update necessary is the new rule number, and one that has some substantive changes.
Okay.
So
2012-03 is the only one with substantive changes.
So three, is that correct?
Well, 1993-02 might have substantive changes if you list all the factors, because the number of factors increased from 11 to 13. But
All
that's-
three of
that's
these
a minority.
Okay, we're
advisories
talking
have
over each
substance.
other, and I think it's driving the audio guy probably nuts, so, just like in a deposition, we gotta talk one at a
Okay,
time.
so Ken, would you like to be added to this? Would you,
Yeah, I've actually done it.
you've done it? Okay.
So why don't we, Ken's volunteered, he's already, done the edit, so,
Is the answer three advisories?
Yeah.
That need to.
yeah, and I think they're
substantive
listed here,
Okay.
the 1993,
Thank
yeah. And Ken, you've made the edits on all three?
Yeah.
Okay. Why don't you share those with us for next meeting,
Well, we can
and then we can
do
vote
them
on it.
now if you want, but just, I don't think, make copies over lunch, or?
Is that possible?
Yeah, I can do copies. Wait, you want me to photocopy them?
Joel, while we're,
Oh, we have them here.
Yeah,
Joel, go
they're
ahead.
there.
My turn?
Yeah.
Yeah, just Ken, if we're gonna do this, leave in the site to the former rule as well, because we're gonna be in a transition period for about the next year or so, where the conduct occurred in the applicability of the old rule, and there might be some change in the new rule that's slightly different, or in the comments to the new rule. So I would just put formerly rule whatever, so that everybody can get on that same page if needs be. It's come up in three arbitrations, or three, not arbitrations, but three expert witness assignments I've testified in, where somebody got confused about which rule applied, so put both in. That would be my suggestion.
That's not hard to do. I mean, the old rule's still there. All we gotta do is plug in the new one and then add a parenthesis and say formally in front
Yeah,
of the
that's
rule.
great.
That's pretty easy to do, so.
So your edits are, I'm looking at, your edits are in red, so can you copy in red?
I think so. I think our
Because
copy.
otherwise, it's gonna be hard to follow.
Yeah.
All right, so we'll get the,
They're kerfuffling over
the
it.
Ken edits
Out in
over
the field.
lunch, and hopefully we can look at those and approve them today.
Oh, I was gonna email the thing to you.
Oh, Ken, one other question I had. On the cross-reference table, there's about a dozen or so rules that had no California counterpart. Have you checked any of our advisories to see if some of those might be applicable?
I have not. What I did was, I think Roy did the checking, it's the ones that needed changes, and he had his memo, and then I went through these three that are in here. I haven't gone back and looked at all the other ones, I was just
Well, for instance,
trusting.
the imputation of conflicts rule, imputation of prohibitions, use of client information, I don't know.
Prospective clients is a new rule.
Yeah,
I don't think we talk about that, and it's on a FIARB issue.
yeah, I don't think we do either, but I'm just saying, there's some new stuff that can't be just picked up because the old rule said it and now we're saying formally.
Right.
So,
Yeah, I don't
More
know
work
that
for
any
you,
of
Ken.
those would really,
Yeah.
maybe this.
and I move that Ken do the work.
All right, so whatever method Ken can get them to Isabel, and we'll look at them over lunch. All right, moving to line item D, 3, review and update arbitrator handbook. Again, this was something that came from the new program people. So Isabel, can you explain this?
I have a question first. I thought we decided we were not gonna use the handbook anymore. Because we had issues with that in the past, there were differing versions, and since we already had the training outline, I thought we agreed to scrap the handbook.
Okay, I only put the arbitrator handbook and the program handbook on the agenda because this was part of the Appendix I transition plan. So part of the decision was that the CMFA would sunset at the end of June, and the committee's tasked with doing certain things before that end date. So if you would like to discontinue the arbitrator handbook and use something else in place of that, that's something that you can discuss.
As Ken said, I thought we decided to stop using it.
Yeah, and
Because
my memory is that Baxter v. Bach had this whole issue where there's different versions of handbooks floating around for 20 years. So in that case, it wasn't even our handbook. I believe it was Santa Clara's own handbook, and of course it was it differed from the State Bar Handbook, and I think as part of that discussion, we did decide that we don't use it. Now, I don't know when we have trainings, because I don't go to every training, what's passed out. Do we still have this version that we give to people when they come to our trainings, Isabel?
Elizabeth's been sending them out to new arbitrators. So if that's something that we should
Okay,
not be
well-
doing, then we should stop doing that.
Yeah, I don't think we ever had them in the training stuff. It was something that was, once upon a time, was being sent out when somebody signs up with their little, well, when we had the
A binder.
binders.
I have an old binder.
Right.
They got the handbook because it was in the original binder, but that's what, yeah, in part because of the Baxter v. Bach thing and all that, I thought we decided to scrap these, so.
So, my feeling is, if we decided that we don't use the handbook, then we don't need to update the handbook. So, Joel?
Yeah, my recollection of the discussions was that we were gonna can the handbook mainly because of obsolescence, but before we did, somebody was gonna go through it and see if there's any pearls that we wanna bring forward into the training materials.
We did that.
And we did that. Okay, then can the handbook.
Yeah. In fact, I think Carol Buckner was the one that went through, and if there was anything that wasn't, I mean, our basic is
Yeah,
pretty
okay.
comprehensive.
That's fine. Great.
And we did chunk out, as you say, pearls. So let me take a vote then. All in favor that we formally discontinue use of the program handbook, raise your hand. All right, so
I
if
offer an
there's no
amendment.
handbook, there's no need to update.
Okay, so
That,
John,
it's
you're a
part
nay
of that,
or
we also
abstain?
inform local programs. If they've got any copies of that, they get rid of it
To
too.
discontinue the handbook?
Um,
Okay, so it's unanimous then.
Yeah.
Did you hear Isabel, Joel's suggestion that we notify the local program that it's discontinued and not to use? to use
Yeah,
it.
if any of,
I don't know that they're using it. I just know that we.
Okay.
But it
have
doesn't matter if
still
they are or
sent
if
it.
they're
I
not,
think
the
an email,
message should
yeah.
be
Okay.
that it no
Okay.
longer
Yeah.
exists.
Okay,
Okay.
sorry, I'm in
Okay.
favor.
So we need to email the locals.
I just was saying, I mean, I was kind of happy, but maybe it actually wouldn't need to be very short. It'd be like just one page, like we put out an advisory. It just said the Arbiter Handbook is no longer utilized, we require version should not be referenced.
Cited.
There's actually just like an official document that just
Yeah.
tells people like, don't look at that.
Well, this is part of the messaging that we need to local programs that, we're not going to exist past June. So if I were the program director or the person in charge, I would have one memo, letter that encapsulates all those concepts. No handbook, no committee past June, whatever message that we want to give to the local programs. If your program is closed, send all your people to State Bar or closest surrounding county. I think those are all concepts that should go into a
But
letter.
my point is taking it one step further, because in the event you have some appeal or some lawsuit that Joan DeNova that's now going up through the ranks, it's like, that's not gonna mean anything. But having an advisory that we know like is part of the numbering and is part of like where you go and have it there, then that's something somebody can reference or not know that they shouldn't be referencing it.
Yeah, I like that, because that could help with the Baxter v. Bach type thing.
Yeah,
So if
that's
somebody
what I'm
gets
saying.
one
It's
of
like
these
there's a
things and wants to
greater
start
good
using
if
it,
we're gonna,
citing
like,
it, if
get
we've
rid of
got
it.
something that says it's invalid, it has no authority, then that undercuts that argument.
So actually, Lee, what you're suggesting is having a formal advisory 2019-01 that says, don't use the handbook, committee no longer exists.
Well, I'm just talking about the handbook.
Okay,
just
all
the
right.
Just about the handbook, just to like let people, put everybody on notice, whether you're part of a program or you're just, a member of the public or whoever, or an attorney out there that has one of these kids, it just lets them know, or the courts, like, we aren't updating this thing is not, valid. I mean, Ken and I could work on proposed language for it.
Yeah. I think that's a good suggestion.
I make a motion that that Ken and I do a little subcommittee and work on an advisory that then we can bring forward. When's our next meeting?
For May 3rd.
So it doesn't involve any work on my part?
No.
Okay, I second that.
Okay, he's not delegating it to you.
Very good.
All right, there's a second. All in favor? Aye.
All right.
Aye.
All right, so I think the same concept would apply to a program handbook.
Like what?
That's useful to local
couldn't hear
bars,
you,
though.
We're on the review and update program handbook. And my suggestion was, isn't that the same concept as the arbitrator handbook? I mean, I
Is
quite
there such a
frank-
thing as a program
Yeah,
handbook?
I've never seen a
Never
program.
even
Is it the
seen it.
program advisory? You talking about the program advisory?
That's the program
it's called
advisories.
program handbook.
Yes, it has program advisories in it.
Oh, okay. It contains program advisories.
It contains program
Is there an
advisories.
actual
That might be
I've never
useful
seen a
because
handbook.
I haven't either.
if you have change of staff, they have something to reference to tell them what to do. If a party dies, or if there's out-of-state counsel, it all has the information in there who they need to contact, what happens. There's copies
So
of
it's
the
a
form.
binder that contains program advisories.
Yeah, it's
I'm
usually
hearing you
given
saying.
out at the round tables that we're not having anymore.
We don't
Yeah.
want to get rid of advisories, program advisories.
Yeah,
Right.
at one point they had a CD that they handed out,
Right.
with all the programs, it's got all the
It's actually
advisories.
very helpful for local bar staff in troubleshooting common problems, like when a party files for bankruptcy.
Yeah.
It breaks it down whether it's
Well,
client
that's
or
fine,
those
but
are-
is there
those are
is there a
advisories.
separate handbook, or is it
Well,
just the
that's what we
advisory?
call it. It's a binder that contains them in common forms, like forms for incarcerated clients, how
So
to.
it's just what's the advisories with the forms that are in the advisories?
Yes, and I only include the index because it was very voluminous, and I didn't think you wanted like 100-something pages. So whoever is assigned to this, I can share the materials with you, and once you determine which things need to be updated, we could include the excerpts in the May meeting attachments. But
So what I'm hearing is, since it only contains advisories, we're actually updating the advisories, the program advisories.
reviewing them and make sure there's nothing that needs to be updated.
Okay.
I don't think, just from looking at the we can look at it, but they're different than the arbiter. I don't think we have anything in there that probably needs to be, we don't reference rules or things, but.
No, they're all advisories on the
No,
index.
they're specifically written for program staff.
Right. Yeah, they're all advisories.
Yeah, I don't think any of the rules changes affected these at all. But.
Yeah. So, with that edit that we will review and update program advisories, is there a volunteer that wants to go through XV11? What does that translate into? 17? 17 of them?
28 of them.
Oh.
26.
26.
Oh, 26. Oh, you're right. I didn't go to the next one. I don't see a hand for a volunteer.
I'll work with you on it. I'll do half the work.
Is there a time estimate on how long it would take?
I have no idea. I mean, some of these you may not need to change because the law hasn't changed. Some of them, the form number may have changed. I don't know. There's some mention of judicial council forms. I don't know how often they update those.
The only one that jumps out at me that might need some changing is 23, procedures for handling MFA where participant has filed for bankruptcy.
Okay, because of that one case.
And because of the Maryland Shear case, had all sorts of stuff in there about the consequences and the automatic stay, and so.
That was enforcement, though. So I think all the automatic stay stuff would change the same. Would stay the
Bankruptcy is
same.
simple. If you get a case in, you have to evaluate, you know, who's, is it a refund or is it a request for more money? And then who's filing? I mean, it's that basic, so.
I'd be happy to take a look at these and report back.
Okay.
Well, we can review them together, yes. And
All right.
review and discuss together. Okay, and that might be useful for Santa Clara, yeah, okay.
All right, so we have
I
Clark.
thought you were chair, don't you chair of Santa Clara?
What's that?
Aren't you chair of Santa
Not
Clara?
presently.
Oh, you,
Former
and
chair.
you haven't read all the program advisories?
Rules mentioned in that would be bought at the state board.
Oh, really? We got, in doing the amicus, or the decert, we got information from one of the party's attorneys that it was Santa Clara. In fact, we got your actual handbook.
It's not in the published opinion.
Okay, well, interesting.
Refers to the state bar's rules.
Yeah.
With respect to arbitrator disqualification, disclosure and disqualification.
And I can't remember if the appellant or.
I just read it.
Yeah, somewhere along the line.
Because I
in one of those
physically
cases,
saw this,
yeah.
I'm not inventing it,
Could have
so.
cited it in a brief.
Yeah, there was.
It was in a brief, yeah. All right, we have a volunteer, Clark, thank you so much. All right, 5, review and update basic and advanced training materials. My thought is that we're all up to date. The advanced are brand new. The basic may have some old rule
So
site.
the only reason why I bring this up is because we have 4 trainings coming up, and so we should update the references to the rules of professional conduct. So that's one concern. I did go through and check the arbitration advisory sites. There's a couple that are superseded because this was actually I'm not sure why, but I did see some where the no, actually, no, that was the arbitrator handbook, sorry. But primarily, I like to update the rules of professional conduct that are referenced here.
Can I ask, where are the advanced training material?
98 to 142.
Well, I know what it says, but I don't see any differentiation here between basic and advanced.
No,
No,
this is
they're
mostly,
different, because
All right, so it's
I work
one
on
set
it.
of material.
right,
Yeah.
and the checklist appears in both. That's why it wasn't delineated between basic and advanced.
Okay, I understand.
So is there a volunteer to review and update the basics and if necessary, the new advanced training materials? Anahid? Okay.
Are the advanced ones, where are the
don't
advanced
see
ones?
these.
I don't
The
see them
advanced
in
isn't in here because there are no rules to the references to the rules of professional conduct. We had just updated the findings and award form, so that's brand new. The only thing that I saw that really stuck out is the screenshots on the PowerPoint, which I know Anahid loves. The screenshots will have to be updated because the State Bar website has been changed around. There are screenshots of the old findings and award form, so that'll need to be changed. And the old language for responsible attorney on the old form is not on the new findings and award form. It just says for the purposes of this arbitration, the responsible attorney is so-and-so. So I don't know if you want to update that finding awards form to have the old language, or if you just want to input a screenshot of the new findings and award form in the PowerPoint.
Well, you guys can work it out.
Yeah, we can work it out.
You know how I am completely incompetent with the PowerPoint.
You could take this as a learning
For the
experience.
Training, Isabel just said I just have to press things. I don't have to do anything.
Or next.
Yeah, I can do that too.
With the arrow, next.
Think about review for the
So
rules
Anahid
changes?
and Isabel will work on updating the basic and advanced trainings, including the PowerPoint. if
Actually, can we go
necessary.
through it today because we need it by the end of February.
I did it already.
Oh, you
but-
did it already? I went through with my notes too, so,
All right, well, maybe we can copy those.
okay.
Oh, I can plagiarize with the best of them, so yeah, that's great. If I can just copy them.
All right, so we're gonna get two things over the lunch hour. It is noon, so lunch is in the back that I see.
Yes, it's a taco bar, I think.
So we'll take our lunch break and hopefully we can look at some materials over the break. We're adjourned for now.
We're in recess. We're in recess.
I used to take a nap.
We go out and play in the sandbox now?
Put your head on the table. No, somebody says adjourn to me, I'm liable to just leave.
So what do we have for advanced training material?
It's like 15 pages.
It's the
Yeah,
arbitration advisory checklist.
Me and
All right,
Carol put
okay.
Yeah,
no,
it's,
that's
it's
fine.
right here. It's starting at page, blah, 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 blah. Starting at page 124.
124.
Yeah.
All right. Because for some reason I'm thinking there's. Okay, got
But
it.
see, they fooled you because then at page 131,
They
they
put-
put in the slides.
From the basic training.
Right.
All right. Okay. I'm
We're
trying to be
just
clear.
testing you.
Yeah.
Actually,
I mean, I
the
rec-
advanced isn't in here because it was in my funky font, it's not the same font, so it's not in. So I didn't include it because I thought it's
Well,
not
wait,
all rules of
isn't it page 1?
Are you flying out of?
All right, I'm calling the meeting to order after our lunch break. Isabel in the printing shop at the State Bar was gracious enough to print out Ken's edits. So let's start with his proposed edits on the 3 arbitration advisories. Any questions, comments?
So on page 2 or 53 of the advisory, that, the redlining, that's gonna go, so it'll say under rule 1.5D, and then it'll say in paren, which now specifically provides, or how's that gonna?
Yeah, there's 3 sentences up at the top of
That was
53.
I actually did that as a note, not, but it's quoting the language. But I think we needed to put something in there now that there's a disclosure required.
So is it gonna be part of the language itself, or it's gonna be a footnote, or I'm not understanding?
Yeah, I'm not understanding either. So I think we're all talking about these three lines up at the top of 53.
Well, that paragraph was talking about a true retainer and non-refundable fees. So that was a note in going through that now there's Rule 1.5D that has specifically defined what is and is, there is no such thing as a non-refundable, and there's a disclosure required.
Should we put a footnote on true retainer, like a 1, and then drop down
Well,
those
let's see,
three
under rules, the attorney and client must have contracts
lines?
for a true retainer. Attorney must refund our portion of the next question. How to distinguish a true retainer?
So, I'm sorry, again, how's that gonna look?
Well, when I went through this, it was a note for discussion.
I see, okay.
It wasn't intended to draft that, but
Okay.
that paragraph talks about a true retainer and what Rule 3700D2 suggests about that. Goes into the Baranowski case, and I would just made the note that, well, I think some of that's now moot to the extent that 1.5D talks about, there's a specific definition of a true retainer now, and there's this requirement for a full written disclosure and consent if you're going to in fact have a true retainer.
So I just wrote an article for my bar magazine on this. What 1.5D does is it's the statutory equivalent of Baranowski. If you are, there really is no classic retainer anymore, but if you're going to use one, you have to get your clients, you have to notify them and then get their consent in writing. So that's now part of 1.5D. So I don't know if we have to put language that basically says that.
Yeah,
Well, it's
I wouldn't state it that they aren't. I've come across a number of retainers.
I think I qualified it with they're rare.
Right, yeah.
And if you're going to do it, you got to jump through hoops.
Right.
Joel?
Yeah, maybe I missed something. Are we going to look at the references to Rule 4200 on page 49?
Well, right now we're on how do we incorporate what Ken now describes as a comment. Do we just leave it alone, or?
Well, he's saying we skipped the first.
Oh, you want to go page by page?
Yeah, because Rule 1.5, new 1.5 adds 2 new factors to the 4200 factors.
Right, but I think if we are going to go page by page, on 49, we're just replacing 4200 with 1.5.
Yeah, they didn't list the factors in the advisory.
Thank you.
Well, but on the next page, it says, taking into consideration the factors listed in 4200.
Right, so all references to 4200 should be 1.5.
Can I get 50 of those?
Yeah, but that also should be a formally 4200.
Oh, well, yeah, we're going to do formally.
Okay, I just
So-
didn't want to miss that because you jumped off into the next page, so sorry.
So all the rule changes will just have the new rule and then in parentheses, add a formally and keep the old rule reference there. So I think we're gonna do that throughout.
Say again, Ken, I'm sorry.
All right, if you go to page
So let's
49
do
now,
49 as the example.
where it says Rule 4200 down there, and then I put 1.5. Now it'll say Rule 1.5, parentheses, formally Rule 4200.
Okay.
Got it.
And we'll do that on all the advisories,
Right,
the
but-
formalies.
And again, this is just a question. The 2 new factors in the new Rule 1.5, I thought were pretty significant and should maybe be called out. And they are whether the lawyer engaged in fraud or whether the lawyer has failed to disclose material facts.
Right, and those 2 factors come from a case. Again, I just wrote an article on it, and I'm drawing a blank on the case, but they incorporated, because they're keeping the state bar discipline component of 4200. If you have such an unconscionable fee that it amounts to fraud, not only can you be in a fee dispute, but you can be disciplined for it. So those two extra factors are from it's an old case.
I agree with you about the two next I guess I have a procedural question, I don't know. It's my understanding if we're just changing the rule reference in essence, so if it said 4200, it says 1.5, we can do that and we don't have to go up to the public comment and board approval, or do we?
I have to ask Donna, because I don't know what would qualify as a substantive change to the.
See, I would say just changing the rule reference is not substantive. I would think we ought to be able to do that without having to go through the whole formal
Well,
process. But
regardless-
if we're adding a discussion of the new factors, then that probably triggers this whole process where we gotta put it out for public comment like CoPrac.
It is what it is.
We'll never get it done by June.
Yeah, but I just thought those were two pretty significant
So we
Yeah.
just have to make the
factors.
changes. And if,
We can get it started so that when COPA has accommodated the 2 or more MFA members, they can continue work on it as members of COPRA.
so, going back to sort of the page-by-page format, on 50, we have two 1.5 replacements. Formerly known as, okay. So we have none on 51. 52,
Yeah, what I did on 52 was I changed 3700D2 to 116E2. And then 116E2 has new language, so I kind of crossed out the old language and inserted the new language, so, because it was a quote, so now to be more accurate.
so it's lawyer instead of attorney.
Yeah, they now say lawyer instead of, and they've added shall and fee or expense, so.
Let me,
In essence, we would just quote the new rule.
So, Isabel's, I guess, tracking changes for word processing. So do you need to tell her where the caret should go up, like promptly, and then caret shall?
is it
Well,
shall
yeah,
promptly?
The rule
Yeah,
says that.
I'll take a look at the
It
rule.
should, since it's a quote, just quote, I tried to insert the words and the highlights where we could, but
Okay.
in PDF, this is best.
Bless you. Bless you.
But yeah, but it should just quote the new 1.16
Okay.
E2.
So 53, we're back to, do we footnote those three sentences up at the top on the definition of a retainer? Or do we actually insert that down after the Baranski site?
Why don't we put a footnote one after the word true retainer in bold and then put what's in red here down at the bottom of the page in the footnote?
So the first reference to true retainer, we'll footnote that before the print, also known as classic. So we'll footnote that. Footnote that.
Actually, probably, that's as good a place. I was looking at that last sentence on that paragraph where I highlighted Rule 3700D2. And it says itself suggests that a true retainer, there's no suggestion anymore. 1.5D specifically defines it, so. So we could just say Rule 1.5 states that a true
Retainer is one that's
blank,
paying, yeah.
because it's defined in the rule now.
Right. So we'll change Rule 3700D2 and we'll say Rule 1.5D defines a true retainer as one that is paid solely for the purpose of ensuring the availability of the member.
Yeah. I mean,
And then
just
should we
quote
say
the
this
definition.
this definition of a true was originally adopted by the Supreme Court?
That makes sense.
Originally,
Yeah.
So we put originally before
Yeah, because
adopted.
that's in 79 and this is the new, yeah.
Right.
I have a question.
Yeah.
Okay, now, I've actually never noticed this before, but the new rules use the word lawyer, who, that word has always been used to denote a person who's gone to law school. An attorney is a person who is licensed to practice law. Those are very two distinct things. But since they're using lawyer here, shouldn't we just refer to lawyer in every space, every place that attorney is listed? I mean, I think it's wrong, but they've gone with lawyer, so shouldn't we then?
That'd be a lot of search and replace. Because look at how many times.
A few our advisories back, we started to use lawyer almost exclusively.
No, I understand that.
And we would go through and actually edit all attorney down.
No, I get it. That. Like I said, I mean, I think that's incorrect grammatically, but that's what they're doing, and maybe that's just an evolution of the language. But you know, since you've identified it on page 52 as lawyer because you're quoting, maybe it's an easy fix. You just go search and replace.
Yeah, I think they just wanted to get away from using the word member and towards licensee, so lawyer might be
Yeah, I don't know.
a function of that.
Do you think that was the reason?
Well,
Do
I
we
don't know.
think that we should do, we'd have to do a search and replace on everything?
Yeah, I mean, what they did was, they didn't use attorney in the old rules. They were members, which they now think,
We're
you
not
know, it's
members
like
of
some
anything.
social club, so they've changed member to attorney.
Well, I paid my dues. I don't know about you, Kim. Okay.
Yeah.
So that's all.
No, we're all licensees.
I
If you
think
look on their
lawyer,
website,
yeah.
we're
They
licensees.
still use
That's
lawyer in Rule 2.4. Lawyer, oh no, never mind. Yeah, this is a new rule. So 2.4, lawyer as a third-party neutral. So they still use the word lawyer.
I don't think we need to do a whole search and replace, except in areas where we're quoting the rule, and the rule says lawyer. Otherwise, you know, I don't. I see what you're
Fine,
saying, but it just seems like a bunch of extra work.
I just saw it and I brought it to the committee's attention. What we do with it is up to the committee.
Now, if we were saying member, that would be different.
Sorry?
They still use the word attorney someplace.
Okay. Okay.
Yeah.
Yeah, maybe we just do keep it a little bit simple right now, and then the powers that be can revisit these. Okay, so we've hit 53. Do you have any changes on 53? Yep. So 54, I think we're just changing it to Rule 1.5, where it's highlighted.
1.16.
Oh, 1.16, that's right.
E2.
E2.
Wait a minute. Is it D2?
Actually, Anahid,
Yes?
the,
Oh, yes.
under the old rules, 100,
Termination, yeah.
it
termination
defined
is
both
on the
lawyer
state.
and member was a restricted,
Yeah, so there's E1 and E2.
it was only a member of the state bar, whereas lawyer was defined as a member
Yeah,
of any
E2.
bar. And the new rules use the broader definition, so I don't think there's anything to worry about.
That seems to have been the consensus.
Yeah, okay, all right.
All right, so we got Rule 1.6 E2 on 54, turning over to 55.
Wait a minute. Oh, I'm sorry, I put it the wrong way. I think that's right.
So there's two lines down at the bottom, Ken. You're adding the two extra factors in. So should we renumber them? You got A and B, and we went through 1 through
Yeah,
11.
they're actually numbered, I think, but.
1 and 2 is what they're numbered.
Yeah, I think they're still numbered. I don't think they're 1.5B. I think they're 1 through 13, as I recall.
Yeah, they're still numbered.
So this would be, like, A and B would be
1 and
12
2.
and 13?
No. They added those two up at the front.
Yeah, it should be 1 and 2 instead of
Yeah.
A and B, and then renumber from that
I
point
see.
forward.
So some of these factors include whether the lawyer engaged in fraud,
Right.
Okay,
That's
got it.
They're keep-
those are the two new ones that
Okay.
Joel was talking about.
Got it.
So we'll renumber 1, 2,
Add the 1 and 2 and then just renumber everything.
Okay, so
they
we're
don't
adding
have-
the 2 new factors ahead of the existing.
yeah,
Okay.
that's how they're listed in the rule. They're listed up front.
Oh, wait, we don't list all of them.
We don't
So
list
the
all of them.
relative
I was gonna
sophisti-
say, there's
Relative
not-
sophistication is 4.
They dropped off after a while. Huh.
So the one that's now says 1, the relative sophistication is now 4.
We add all of them?
The amount of the fee is, so what was number 2 on the top of page 5 is now 3. The experience and.
Why are we including anything? Why can't people just go to the rule?
Well, these advisories exist, so we're not rewriting the advisory. We're just updating it. So we're taking what's existing there and,
If we're, okay, the problem now is the advisory only listed 3 of the 11.
Right.
And if we're gonna add the 2 new ones, and we correctly number these, it would go 1, 2, 4, 3, and 10. So I would suggest instead of denumbering, I'm just saying, including these factors,
but
whether
it,
the lawyer engaged, semicolon, whether the attorney,
Right.
semicolon.
That makes more sense.
but there's a qualifier in the sentence that says, some of these factors include.
Yeah.
So it's correct.
Yeah, but no, I'm just talking about if we're keeping the numbering, if we went 1, 2, 3, 4, 5, then it gets a little confusing. Why don't we just put?
Yeah, we'll just do them
yeah,
sequentially.
with the.
Because
with-
some of these factors include
Yeah.
1, 2, 3, 4, 5.
No, I'm saying take out the numbers, just put.
Oh, yeah, you don't
yeah,
need
just-
numbers.
Just put the semicolons in between.
Yeah,
Okay.
I like
But
that
you
better.
want the 2 new factors to be
Yeah.
in the front. Okay.
We're only listing some of them.
The 2 new ones are biggies. so-
Yeah.
Okay, and then omit the numbers.
Ken,
Yeah,
on page 55, where you have it unconscionability, 1.5B, is 1.5A, I believe.
0.5A. Oh, yes, the first one I guess would be A.
So under C incontrovertibility, that first site to 4200,
And then the factors is B.
all right. So
Yeah.
1.5B formally,
Yeah, that's A and this is B.
yeah. Okay, so then the second one down at the bottom is 1.5B, okay. All right, 56. So we're getting rid of the numbering on the first paragraph.
Using
So you got a little
semicolons.
thing out on the side, also must comply with, is that a note to yourself?
That was another note, comment on this. True returns therefore should be scrutinized to see if the fee is unconscionable. I thought we should probably also add that it also has to comply with 1.5D, because if they don't, it's not just unconscionability, but now there's
Yeah.
there's
It-
a
it-
specific
well, I would say
requirement of
af-
disclosure and
Right,
consent,
I
so
would
just
say
add that. Yeah.
two retainers should therefore be scrutinized. In addition, the attorney must give notice and obtain written consent from the client under Rule 1.5D.
Wait, what was that? Sorry. True retainers.
My brilliant,
Yes,
solution.
true retainers must be scrutinized.
That's already in there.
Okay.
So it's after
But, yeah.
unconscionable. In addition,
Addition.
Rule 1.5D
Well, how about
requires.
this? It said true retainers.
Excuse me.
I got an alternative suggestion that I think is easier.
Well, let me get mine
Okay.
out, and
Hey, jeez.
then you can add.
Yeah.
In addition, Rule 1.5D requires the attorney to provide notice and obtain the written consent of the client. Do you have something that's more
I was gonna
That's
say,
better than that?
Well, I don't, but a true retainer should therefore be scrutinized, see if the fee is unconscionable and whether the attorney has complied with the disclosure requirements in 1.15B.
Too wordy.
That's less words. I don't think it makes a big difference,
Yeah.
but that was just my suggestion.
Okay, so Lorraine wants 2 sentences, you want 1 long sentence?
Yeah.
Okay, so in addition, Rule 1.5D requires the attorney to obtain
To provide notice and
Provide
obtain
notice, okay.
written consent from the
by
client.
notice.
Well, disclosure.
What?
Disclosure, not notice.
Requires
That's the term of art.
disclosure, okay,
And,
Client.
and obtain written consent from the client.
and obtain written consent from the client. So provide disclosure to and obtain written consent. Okay. It's page 56.
The rule 200B,
1.15B.
okay, so that's 1.5. B is in boy,
B is in both.
okay,
Little b.
little b.
Unconscionable.
4100, yeah, that's where you put money, so that's 1.5 now.
Okay.
1.5.
1.15, right, formally. So, the stuff on the side changed to quote new 1.5.
Well, we're quoting the old rule, so we need to quote the new rule. As long as we're quoting the new rule with the advanced fees, it probably should add something, because now there's the new requirement for the flat fees as well. so.
Right. That's a lot of word processing.
Yeah, well, I mean, 1.15A is the general one, and then 1.15B
Is
is the
the
one with the
exception,
flat fees.
right.
Okay, so you want to replace the current paragraph at the page 56 to 1.15A.
Yes, the quoted part.
Okay, and then you also want to add a discussion of 1.15B.
Yeah.
And then the highlighted part is now 1.15C.
Yeah.
Okay.
Page 30.
All right, 57,
Well, that's easy. It's all moot.
So 1.15C, is that rule 4100's
Well,
prohibition?
4100 is now, well, 1.15C is the no commingling.
Okay, so it should say, therefore, rule 1.15C, formally rule 4100's prohibition.
Oh, let's see, 1.15C.
On commingling.
Says.
Okay.
It's a true.
Commingling is C, right? Funds belonging to the lawyer should not be deposited otherwise commingled, except.
Yeah.
But that sentence though is talking about true retainers, which is now handled by 1.15D.
I know what they did. Didn't they break it up into 2 separate rules?
They did
So
all
it's-
sorts of things.
So 4100 doesn't
Well, 4100.
cover area, yeah. Yeah, they did, look, 1.15 and then 1.5.
The 4100 became 1.15.
It's just,
But that sentence, that last sentence is talking about true retainers, and that has its own specific thing in 1.5D. Which says,
I'm like, I'm wondering if I'm needed.
well, I guess that would still be, true retainers should be placed in
what, then,
proprietary accounts, so I guess that's still the law.
yeah, the trust account.
Yeah, so that's still, no. True retainers,
True retainers are earned upon receipt, so they don't have to.
yeah.
Yeah. We just gotta get the rule right,
don't
which
know
I
if
think is 1.5C.
Yeah, so I
It's
think
a
that
commingle,
statement, I
yeah.
think that statement is still correct. That's why I had the question
Right.
marks, was to check, make sure that
Commingling is
statement was correct. Yeah.
1.5C, so we just replace that and then get rid of that.
Yeah.
All right, so I'll,
And then those next two paragraphs
out,
are pretty much, yeah, that's all moot.
yeah. All right. Moving on to handling legal malpractice claims, advisory 2012.03.
Hold on, so that footnote 3 will disappear too if you omit those 3 paragraphs.
Right. Yeah,
Yeah.
that whole page goes
So
away.
that'll
Everything goes in trustee.
Okay.
So the first edit on
63.
that is on 63. Oh, wow.
Yeah, that was tough
Yeah,
because they
yeah,
broke
because-
3310
yeah,
into a whole
exactly.
bunch of stuff.
Yeah. You know, I had to deal with this issue in an actual case. I was writing a brief. So what I did was we could say, this is my suggestion, formally rules and then keep them in and then add a new sentence at the end of that paragraph that says these rules are now, and then just list them.
Oops, I missed the 3700D one.
So, yeah, I saw that. So my way of dealing with all these Frankenstein rules now is just to say, these rules are now found in, and then cite them, 1.81, 1.7, 1.87, 1.9, and 1.86. That's just the easy way.
Okay.
That's fine.
And then we have to change 3700D in that paragraph to 1.16. E.
And the next one was just a comment that it's talking about the,
Oh, Shepherd.
yeah, the
Yeah.
disgorgement.
Well,
and
that's a
conflicts.
Supreme Court case that,
So it's a question whether we want to update the advisory now to deal with the Shepherd, which I think goes through that whole process of public comment and all that.
yeah, I'm trying to think how, I'm making a determination now. Well, I would say after that first sentence, the arbitrator has several options. In the Supreme Court case of Shepherd Mullen versus JM Manufacturing, I have the site. The court gave guidance on this issue. I mean, you could go into a whole, new advisory on it. And then they get the site and they can look up the case. Unless someone has more. Joel?
I think you gotta do a little more than that, because
Right, you're trying to advise.
flip the whole switch over to reasonable value determinations. And I think
Well, okay.
recognizing
I-
we're gonna be booted out of here in a couple of months, we ought to
Yeah.
at least give it a try.
I take Shepherd to say that if you violated a rule of professional conduct, you can void the fee agreement and not enforce it. And then the issue of whether the attorney has to disgorge his or her fee or is entitled to reasonable value services is multi-factor.
Well, that's not what Shepherd Mullen says.
Well,
Shepherd Mullen is not
that's what I
like-
took from it.
It's not like 6147 and 6148. It doesn't give the client the choice to void it at his option. It makes the contract illegal. And then
Against
it
public
leaves
policy.
open
Yeah.
the attorney's ability to bring a separate claim for reasonable value of the services. That's exactly what the case says, and I
Not a
just think.
separate claim.
Yeah. It says in the final
What do you mean by
paragraph
separate
before
claim?
they get into the reasonable value discussion, they say, therefore, the agreement is void. And I think the language is something like, but Shepherd Mullen did not have an opportunity to raise its claim or its additional claim for reasonable value.
No, in fact, they argued in the Court of Appeal, we really didn't do, our waiver was in good faith, and so we want reasonable services. And the Court of Appeal said, no, your conflict permeated the entire relationship, and we're going to order you to disgorge.
Right.
It went up to the Supremes, and they said, void, unenforceable, impermissible conflict, and we don't like the absolute disgorgement. We're going to send it back to the trial court.
But Lorraine, what Shepherd Mullen had done was to raise as a separate claim in the case, before it hit the appellate trail, the reasonable value.
Yeah, but it's not a separate lawsuit. That's what I
No,
hear,
no, a separate claim.
Yeah, separate claim is different.
And so it doesn't give the client the option to void like you would 6147, 6148. It says if you want to raise a separate claim in your lawsuit for reasonable value because your contract is out the window, you can, and here are the ways you prove that claim.
So how do we incorporate
it's a different,
How do we incorporate it in this advisory?
and
then?
there are different factors than we've ever articulated as a committee for how you determine that reasonable value.
Yeah.
One of which being the deterrent effect.
Well, they took it from the restatement.
Yeah.
So how do we work this in without it becoming a separate advisory on Shepherd Mullen?
When I noted that, I thought we just had that paragraph needs to be modified now to include the discussion of Shepherd Mullen.
And I'd be happy to get with Ken and take the deep dive, but I think we just can't say,
Well,
go see Shepherd Mullen.
I agree. I mean, if I at least get what we want done before we're disbanded, and then it can do whatever it's going to do from that point forward.
All right, well, I thought we were gonna
In the wire.
try to get these revised and approved today, but if someone wants to chunk out a whole separate paragraph on Shepherd Mullen, what's the consensus of the committee?
When's the next meeting?
We need a discussion of Shepherd Mullen.
Yeah, I think, we can't even agree what the case says, so.
Well, then a separate discussion will help us sharpen our thinking.
Yeah, I look at the decision tree on Shepherd Mullen as, we have a conflict. Maybe void is not the right word because you attribute void to 6148, 60, so we say unenforceable against public policy, because I remember those are the words of the case. And then the second decision tree is, as a plaintiff's lawyer, I love disgorgement. Get back everything you paid. But the court said, no, we're not going to take that absolute. We're going to do, under certain factors, we're going to look at reasonable value of services and all that restatement factoring. That's how I look at Shepherd
Well,
Mullen.
but see, I agree with you, but with one issue with what you just said. I think once you say it's void,
Unenforceable.
reasonable value becomes the attorney's ability, if any, to claw back some value that they delivered to the client.
But it can be zero under disgorgement.
Exactly.
The conflict can be so egregious and permeate the entire relationship that the attorney has to refund everything that's been paid.
And it's exceptional. I mean, it's, I think, additionally important with the new change in Rule 1.5, because one of the things that would make the contract or the, quote, value of the services unconscionable was if they defrauded the client in mischaracterizing or failing to disclose the conflict egregiously on purpose, et cetera, by, failing to disclose all the facts. And that wasn't really raised by the Supreme Court. But I just think there's a lot going on. And in the one case where I did testify as an expert, and the court agreed with me, not the court, the arbitrator panel agreed with me that it was void, out, goodbye, zero, subject to clawback. Then they went on and danced around, and then another expert was going to do reasonable value. And they just danced around that in the, it's illegal part. It was crazy. And
Yeah.
I think to the extent that it just doesn't sit right with me that we just say, go see Shepherd Mullen.
All right, so what I'm hearing is maybe we'll approve what we can do today, get as far as we can, subject to Ken and Joel preparing a short paragraph that summarizes Shepherd Mullen versus
Yeah.
Manufacturing. Because I don't think we need more than, you know, a paragraph or two.
Yeah, that's kind of what I had in mind.
Okay. Does that sound like a plan?
Does to me.
All right.
I think you and Joel are saying the same thing with different semantics.
Okay. I think we are too. All right, well, that was the end of it. Yeah. Yay. So, can you all get the paragraph to Isabel, like by what today is, by the end of the month?
I think there's 3. I thought there were 3 arbitration.
Yeah, I thought there was 3 too, but
Oh, no, we did, okay.
Is this
Okay, we
the
did.
training outline stuff we just
how
got?
quickly?
Yes, that's the basic,
Okay.
the arbitration.
So let's turn to second handout at lunch. The arbitrator training outline. This is just the basic outline. So let's go page by page again. And the first edit I see is on page 100.
That was more of a comment.
Yeah,
We-
that's-
we had
that's not a
talked
rule
about- We had
change.
talked about that in the past, that it's really not jurisdictional, but we left it, so that was just a comment.
That was a Ken idiosyncrasy. All right. All right,
The
so.
only reason I raised it is I have had people call me about that, assert that it is in fact jurisdictional and it's not an affirmative defense that can be waived.
I don't think a statute is jurisdictional. It's an issue that has to be
Yeah.
adjudicated by the arbitrator
The
if
problem
it's
is-
raised by the parties.
The problem is, we have under this section threshold challenges to jurisdiction.
huh.
We had talked in the past about moving it somewhere else. Which
I think it was
we-
there
we-
because you took the position that an arbitrator
No,
could
it's-
refuse to hear the case.
it's-
And I took
yeah,
the
yeah.
opposite. You have to get evidence.
It's always been in the training thing under this section of threshold challenges to jurisdiction.
Why don't we just make it a 1V and call it statute of limitations as a defense? Or it could be, yeah, 1V. Why don't we do a 1V on that?
I'm sorry, what now?
What page are you looking at?
We're looking at statute to get from under the jurisdictional heading of 3 and make it its own category. So chunk out. How far do we go on that?
Well, if we make it its own category of, defenses or something, then we'd have to number from that point forward.
Yeah.
That's not too hard.
Yeah.
but-
So
you want to
get
make
that out from under jurisdiction and make it
an old 5E?
yeah,
That's what you want, so.
if that works.
Okay.
Yeah, we just, its own thing, statute of limitations is defense.
Yeah. Now, solve the issue. Yeah, Roy?
As a consumer protective agency, when the defendant, when the client is unrepresented, is it the duty of the arbitrator to raise any potential statute of limitations issues?
No. That's what the advisory says. Or at least that's what we recommend in the advisory.
Yeah, statute of limitations works for lawyers. So I don't know if a client would ever raise it because it's a lawyer defense. But if the lawyer does raise it, I think, whoever's the arbitrator has to listen, and if the client isn't, giving you the comeback, you've got to elicit some information from the client. And 340.6 is a new or should have known. So you gotta, maybe ask some questions. When did you first realize that your attorney screwed up?
Well, that's my take on it, that I think the arbitrator needs to raise it sua sponte if the
No, because
client
it's
is
a lawyer defense, and
unrepresented.
if the lawyer doesn't raise it, it can be waived. And you're not gonna raise it on behalf of a client, ever.
Aren't we there to protect the client?
Right, and it's a defense for the lawyer.
It might be either way.
No,
Could be either way.
340.6 never works for the client.
If memory serves me correct, what we said in the advisory is, to the extent it's the defense for the lawyer, it should be incumbent on the respondent lawyer, and the panel shouldn't raise that as a defense unless the lawyer does. It's been a while since I looked at it. I think we said in there, though, however, if, say, the attorney had requested fee arbitration and his claim is, or her claim is time barred, that the arbitrator may want to bring that up or something to that effect. It's discussed in the advisory. This is the training guideline, the handbook outline.
Did you want to comment on that, Nick?
No.
Just to follow up on Roy, there are instances where I've had late claims by lawyers under the 4-year breach of contract or the 2-year quantum meruit.
But it's all 1 year now under,
No, the attorney's claim is still, the attorney's claim for payment against the client doesn't come under 340.6, it comes under contract.
no, I'm drawing a blank on the Supreme Court case in 2015, and they said everything is 1 year except for fraud
Well,
and
but they didn't say the reverse.
and larceny.
No,
They said, the client's claim, they didn't say
That's
the
the
lawyer's
client's
claim.
claim.
They left
That's
that,
a contract claim,
Well,
it's not a performance claim.
so the lawyer gets a longer statute, but the client doesn't?
Right.
Correct.
I don't think so.
Yes.
But
No, we've discussed this, Lorraine.
Yeah, wait, didn't we say, of course, that even though the statute may have run had the client initiated it, you still get it as a set-off?
yeah.
So I think he is right, but the way we've discussed it in the past is that we don't bring it up sua sponte as arbitrators, but we put the burden on the attorney to prove every element of its case, including that it was brought timely.
Right.
yeah. But I think we said conversely, it was a situation where it was the attorney who initiated a fee arbitration and the client agreed, not knowing that the attorney's claim may be time barred, that, in those
It would revive,
circumstances, the
right.
panel could look at that sua sponte, as basically under consumer protection type thing.
Because we have an advisory. What's the 2015 case?
Lee versus
Lee
Hanley.
versus Hanley, yeah.
I think we said, I think.
No, that's
we
what,
discussed it.
you wrote the advisory, that's what we said. All right, moving right along, I think the next edit appears on 106, and that's just 1.16E1. Now, why did you put comment 6?
I'm sorry, what?
Comment 6.
Comment goes to the, comment drives the finding the file on their own expense.
Yes.
Oh, right, yeah.
That's where it actually said, the rule doesn't say it, the comment says it.
Oh, you want to specifically refer to the comment?
Yeah.
Okay, all right. Yeah.
Yeah, the rule never said that, it was the comment.
Comment,
that said it.
exactly. All right, next edit, I see is on 112, but it's to a CCP and it's crossed out.
12. Oh, yeah, that was just a note to myself, whether 128.2 actually applies to fee arbitrations. Because some of the, remember.
Is that the hearsay? No, that's not the
That's
evidence code.
No, that's the one that talks about the rules of evidence don't apply in a contractual arbitration.
Oh.
I don't know.
Well,
if
I don't
that-
think we should
I
have
couldn't-
that
I
there,
couldn't
huh?
determine whether it applies in fee arb or not.
Well, we've always taken the position.
No,
that-
yeah, exactly.
I mean, some of those don't. That was why I had a question mark. 'Cause
Huh. I don't even know why that site's there.
Because
if
they-
it's contractual fee arb.
Sure,
none
but
of-
it
none of
does
that-
appear as sites throughout. I mean, there's not too many of them, but they do.
Probably analyze.
Yeah, akin to.
Right, exactly.
And I thought.
Because if you had hearsays not prohibited, what could people say in a fee arb?
Well, in mine, they say all sorts of things.
Doesn't paragraph 2 include paragraph 3?
I'm sorry?
No formal rules of evidence apply.
Yeah, that's true.
Hearsay is a formal rule of evidence.
It is. But the reason I was questioning that, because I hadn't really thought it through before, but I went back and I looked at the B&P code. I didn't see anything in there that says that.
No.
That rules of evidence don't apply and that hearsay is permitted.
No, we get
It's not actually in the statute, so that's why I crossed it out.
All right, so we'll ignore that as
Yes.
a Ken note to self. Yeah.
Why on page 113 are those highlighted?
It's in as a C example.
Yeah, right now, we're not tweaking these for, we're just tweaking them for rule changes. Oh, Isabel says we can make all the changes, so we'll be here for the next week, folks.
Your handbook doesn't.
The priority is to update all the references to the rules
Okay.
of procedure.
Yeah, because I thought you and I were updating these.
The training program doesn't have to go up to the board.
Oh, that's what I signed up for. I see.
So John thinks we should change 3 to hearsay is okay?
No.
No, wait, whoa. Look, remember.
It's a double negative, according to John.
No, just remember that the reason that you get discovery or hearsay is because all the rules of evidence are in.
Out the window.
What you do in a trial.
Right.
None of those rules are incorporated into Article 13, which is our statute. So you don't get any of those rules like hearsay and discovery and all that stuff.
I don't know if we should get that technical. I think the import of it is, hearsay doesn't apply. So if you hear an objection on hearsay, you shouldn't have objections. But
And since
anyway,
it's cited as a C example, I thought it was okay, but. So we're leaving it then, or?
yeah, unless John wants to. No? Okay. Next, we have some highlighting in yellow on 113.
Yeah, I don't
Is
understand.
that note to self?
Well, I've never liked that section where it says client's conduct must be taken into consideration, and particularly like subpart C, whether the client.
May
What?
also.
Yes, but whether the client made reasonable efforts to communicate with the attorney about the fee dispute. I mean, it's the attorney's duty to communicate with the client.
And I know Lee and I disagreed because I remember when we did the advanced training, and your point in San Diego was the client had like 2 years to complain about the bill and didn't, and then I said the opposite, that it's very hard for a client to communicate with the attorney, much less tell the attorney in the middle of a lawsuit where the attorney is representing the client. Hey, I think your bills are, blah, blah, blah. So, we have different schools of thought within this committee. And then there's the case, and I'm drawing a blank on the site, but it basically says that you can't put a time limit in your fee agreement or on the client to object, because I typically see in a fee agreement, you have 30 days to review our bill and tell us of your objection. Well, there's a case that says no. Colbert or something like that.
Yeah, and the reason I highlighted that is I've seen awards.
Or Chandri.
There's two different things.
Yeah.
There's the Charney versus Colbert case, which said that if you have, in essence, an artificial statute of limitations, which was if you don't let us know in 10 days, it's barred, that's out. But you can have, we will assume everything is correct if you haven't let us know within 30 days. And that,
Yeah, I don't like that
because
at
it
all.
doesn't bar anything, and it encourages the client to communicate with the lawyer if there's a problem.
Yeah, and I think we have that in our sample form fee agreement, that it basically says communication is great and, you know, try to do that, but it's this this is me talking, it's the uneven bargaining when your lawyer is representing you. And I have, you know, a lawyer that represents me in trust administration, and sometimes I get his bills and I have like a little heart murmur, you know, and I think, God, do I bring it up to him or do I rock the boat? And that's the mentality that a client goes through. And I've always had a problem that you take that against the client. You hold that against the client if the client is silent for a long, long time. And you go, oh, God, you should have spoken up about that.
Can I make a comment? I think from a standpoint of training arbitrators, that informing them that they may consider the client's behavior with respect to a fee dispute is important. It's an issue I always inquire into, because I'm curious to know as to whether the fee dispute evolved more as a result of the outcome of the matter versus as a result of actual ongoing unfair billing. So I always ask the client if they received bills, if they reviewed them when they got them, and if they ever raised any issues prior to raising a dispute of the final fee.
But if they don't, do you hold that against them by default?
But I think for training, it's a factor that an arbitrator should explore, because it may be probative one way or the other with respect to the nature of the dispute. Many disputes, fee disputes, as you know, are prompted by an unfavorable result.
Sure.
Right? The client doesn't like what happened. And that's a significantly different issue than if the attorney is engaging in unrealistic billing throughout the course of representation, and the client makes a note of it.
Yeah, I don't disagree with you. The reason I have concerns about C is I've had this discussion with arbitrators. I've had awards where they've talked about, you know, the client didn't do this or that, and then and we have concerns about the award before approving it. And I've had arbitrators reference this. Your training says we look at their communication, you know, and it was in essence imposing a duty to communicate on the client that really belongs on the attorney. So it's the subpart C of that section that I have issues with, just because I've seen it pop up in awards. I've seen arbitrators reference this and saying, well, the client never said anything, the client didn't do this, and they have a duty to communicate.
Sure. Well, I don't think I don't think that can be held as a factor in making a determination on the merits. But I think it is probative to some degree to the overall dispute. We don't see fee disputes where clients and attorneys communicate on fee issues.
Right. They resolve it before, so they never get to us.
They don't go to arbitration.
Yeah.
Because clients and lawyers work it out. But I do believe that the communication between the client prior to termination of the representation is a factor that arbitrators should explore.
What if we neutralize that and say whether the client and the attorney made efforts to communicate?
I think that's fine.
Go ahead.
I have a question or a statement. I think it is a factor, and I think it's a legitimate factor to take into account. You know, I assume that adults are engaged in signing contracts. Adults are engaged in interacting with one another, and I understand that it's a little bit of a trepidatious feeling to tell your attorney that he or she might be charging you more than you think is correct Absolutely. But the same thing, Citibank charged me something. I'm going to talk to Citibank. All of this, I understand it's not the same thing. But perhaps instead of they both have a duty, just take that duty part out of it. Say, while not a duty, you may take into consideration the reasonable efforts made by the parties to communicate with
Yeah,
this.
I like
so
the
just to
parties,
identify that
right.
it's not a duty.
Right, and not just the client that has to.
Right, the
to
parties.
open up the bills, because I've had cases where the bill comes in and it gets thrown in a drawer because they don't want to go back to the lawyer and rock the boat and then have the lawyer say, I'm not going to represent you anymore. And, after 2 or 3 years of litigation, not many clients want to get a new lawyer. That's what a client of mine testified to,
But
I was
I'm
silent for a long time because I needed this
I have a
guy to
case right
defend me
now.
in this
I have a
case.
case right now I just heard. I've got to write the opinion. And absolutely, the fact that the client sat there all the way to the bitter end and didn't say boo about anything until he got to the end, and now he's like complaining and he can't even explain what he's complaining about. He's just like, well, I just think that I was like, it just seems like a lot.
Yeah.
I'm like, okay, well, did you ever say anything along the way? Because part of his whole argument was, I told him to go immediately to trial. But then emails are being distributed telling him the attorney to wait. And then the fact that they ended up in settlement discussions for 3 years, the fact that the client wasn't communicating to the lawyer and couldn't prove that the lawyer was not doing the directions that the client wanted him to do. I mean, he can't come to arbitration and all of a sudden say like, I
didn't like anything
I didn't
he
like
did.
what he did. I mean, and how is it on the lawyer to communicate to the client other than sending him the bill that there's a billing dispute? Because the attorney's not going to think there's a dispute.
No.
It's the client.
Yeah.
I mean, it's like Ani
obviously
said,
you sent him a bill
if I get my bill and it's just like I had Ray, like husband, like represent me in something. And I got the bill and I was like, well, wait a minute. Like, we didn't talk about this. We didn't talk about that. Can we we talked about it. I wasn't going to let it sit for like 6 months and then be like, oh, like it's okay.
Yeah.
But you're a sophisticated client.
Yeah, Joel, and then maybe we can come up with like the parties or include the attorney in here.
I don't know if any of you are old enough to remember Ann King, who was one of the very few non-attorney arbitrators in LA when I first started practicing 100 years ago. But Ann had a really interesting way of attacking this problem, a lot more succinct than Lee just did. When the client would say, I didn't know there was this, I didn't know there was, and Ann would I saw her do it twice. She'd look at the client and say, if you go to the supermarket and you get home and you read your receipt and it says there's a can of peas in your bag and it isn't there, you go back to the store and ask somebody, don't you? Stop them every time. That is the kind of client conduct that I think arbitrators can take into account.
Well, but the difference is, a client knows a can of peas, a client doesn't know a motion for summary judgment, right?
Yeah.
Or a case management stage.
And the client hasn't been in litigation with the same lawyer for 3 years and is coming up at a trial and doesn't want to rock the boat. So I think we could like neutralize this maybe, because I think we're a little bit, long on
I have a
this.
suggestion.
Conduct can be taken into consideration or something.
I do think
suggestion
we
would be
should add, while not a duty, so that it deals with what, Ken was saying about some people thinking it's a duty. I think that is force feeding to the arbitrator, but it might be helpful.
How about
While not a
re-
duty.
While not required.
Okay, however you want to do it.
My suggestion would be, take it out of the client section, make a new subpart 4, and then say the arbitrators may look at the communications between however we had it phrased.
Right.
But so it's not under
Right.
the, under the
That's
client.
fine.
Yeah, I like that. I like that.
Yeah.
That's fine.
Efforts
So
to
new
communicate,
4 and
prior
then
communications or something.
4 and then whether the
Parties.
Parties.
Or
client and attorney, that's only parties. Whether the client and the attorney made reasonable efforts to communicate with the attorney about the fee dispute or amounts charged being incurred.
By the way,
That's fine.
Yeah.
I think
Right.
Ann's point was,
if you knew enough to ask about a can of peas, because you knew what a can of peas was, you'd certainly ask about something you don't know what it is.
Especially if the can of peas was central to your recipe. All right,
Why would you even use a can? of
next, edit 114.
We're taking C out of 3.
Yeah, okay, yeah, yeah,
Yes,
yeah.
we're adding a 4.
Writing a 4.
Right.
That will be this 3, except it'll say whether the client and attorney or
Yeah.
attorney.
Need reasonable efforts to communicate about the fee dispute.
Okay, but we're keeping subsection D, that'll be the new C under
Yes.
C? Okay.
Oh. There'll be a new 4 and just drop down C and add. All right, so we just have a couple of rules on 114.
Okay.
Those look good.
They didn't want to pay.
Formally, right? 115. I don't see 4200. A, what would that be?
I guess 1.5A. 1.5A.
Yeah, 1.5 little a. Little a. 1.5. So the only one he doesn't have is that one. All right, 116. You have a couple sentences up at the top. Also, new written disclosure and consent requirement. Was that a note to self?
This is talking about.
It's the retainer, the classic retainer.
Yeah, that's the correct rule, the new one.
Yeah, there was a note whether we should add, there's also now written disclosure and consent requirements, so arbitrators are aware of that.
Okay, we could do that under Rule 1.5D, and then just mirror that language that we had before. The attorney must provide written disclosure and obtain consent from the client.
Yeah, because that's in addition to the Baranowski, it's only enforceable if it was blah, blah, blah.
Right. So we'll just add that after the Baranowski site. All right, 117. Both Rule 200B there has to be another one on 1.5B below. You got that one? All right, 118.
That's got that.
Oh, yeah,
whole
we have
three.
to, why don't we just adopt what we put on the other one?
Yeah.
These new rules are now, and then list them all.
Well, the 3,300 is clearly 1.8.1. 3,600 is clearly 1.8.6. It's the 3,310 that's broken into a whole bunch of different things.
You want to break them out then?
Well, we could.
No, just list them.
We gotta let the lawyer do some work.
How about we do this? This one we could maybe do it in reverse. Instead of putting in the new rule, Rule 3,300, now Rule 1.81.
Oh, yeah, we could do a paren.
3,310, now rules 1 point blank, point blank, 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 blank. And then,
Well, they are, look.
Yes.
In the,
that's what it would say
okay.
now,
All right, I got it right now. Now.
and then 3,600 now, Rule 1.18.
Yeah, fine.
Yeah, no.
It's hard because that
No,
3,310
they broke it
is
into
four
three.
or five different things now.
So I still don't see why we just can't do rules 1.7, 1.1.
That's what I say, these rules are now and then list.
That's it. I mean, I don't see why. If they have the capability of reading, they hopefully have the capability to understand what they're reading.
Yeah, well, so you're saying just say,
Yeah,
California.
add a sentence, these rules are now, and then list
No,
them.
I think what she's saying is we said, see California Rules of Professional Conduct, 1.811, 1.7, blah, 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 just cite all the rules.
Yeah, that's what I think.
Yeah.
And then you can, to keep
For-
it in
formerly
conformity with every,
rules, blah, blah,
formerly,
blah.
yeah.
Joel has a look of disgust on his face, so.
We have to spoon feed these
No, I'm
words.
just, if you're using this teaching guide to go on forever, you'd want to state the new rule and then say formerly.
When
Yeah,
when you're doing the training,
That's
Joel,
just maybe
you'll
my
be able
hubris of
to,
figuring we'd go on
you'll be able
forever.
to say, now, when I refer to 3,300, I'm talking about 1.8.1. And when I
But Joel will
refer,
refer to the new rule at all times.
yeah, and when I refer to 3,310, it's now Frankenstein into 1.7, 1.87, and 1.9. And now 3,600 is 1.8.6. If anybody needs a mental break,
As your audience gets a glassy-eyed look on their faces.
we can refer you to counseling.
The other bar.
Well, just
That's the only
The other bar for the role changes.
Because that's still in
about a
existence.
year or two at the most. What the
I'm
old
gonna
rules were
I'm gonna
aren't
form
gonna
a new
matter.
section. The other bar
All
for
the
the roles.
conduct will be under the new rules. So that's all.
Isabel, I think what the plan would be.
All
right, and
Now
Shepherd
it
Mullen,
says,
what are
"See
we doing with those
California
guys
rules
again?"
of professional conduct, 300, 310, but
Ken and I are gonna fix that. Did
right
you hear
there,
that?
For B
put
and
all
C?
the new numbers.
I mean,
Yeah.
B and D.
And then in parentheses,
We were just gonna
formally
fix the
rules
advisory.
3,300, 3,310, and 3,600.
Thanks.
All right.
So you want me to do the former, you want to put the new rule?
The new rules, just list all the new
Right.
rules, and then in parentheses, formally rules, well, 3,3,
Okay, so the
they
same
can figure
format-
all that out,
Same
yeah,
format
yeah.
as arbitration advice.
Yes.
Yeah,
Formally, okay.
they can figure out what's what.
All right. Do we defer the addition of Shepherd Mullen pending receipt of the paragraph from Ken and Joel?
Yeah.
Or do we just need a site? Do we just need a site?
I think we just need
Sort
a
of- sort of
sign.
the- Sort of the KISS principle.
We need
Yes.
we need this outline for the end of February.
All right, so,
So
No, I think you just put the
I think we can
Shepherd
just put
Mullen
a
case.
site on, under D.
do you need me to go online?
Well, both.
Or you might say revised advisory opinion or something. I don't know.
No, we just cite
No.
Shepherd Mullen versus JM Manufacturing,
Right.
2018,
Yes.
blank, Cal 5th, blank. So I'll just,
That's what I think.
I could go on Google right now.
I got it
Oh,
here.
you got it?
It's so important what I think.
2018, 6 Cal 5th, 59. Shepherd Mullen, I'll send you an email.
No, I got it right now.
I
Yeah.
don't have this section.
All right then.
Yeah, okay.
And then we'll do it after the David Welsh case, too.
That's fine. That's easy. Then we can have a 3-hour discussion on it if you want.
Yeah. All right, I think that's it, huh?
Unless I missed something, yeah.
I think so.
All right.
There's still more training.
There's the award checklist, there was one in there. Page 127, needs a couple of 1.5Bs.
Oh, okay, yeah. On the 4,200, right?
Those were the only ones in there.
Step 11, we might want to add Shepherd Mullen. Serious violations of the rules of professional conduct. But if they go back to, is 2012 your legal mal? Yeah. So refer them back to the arbitration advisory, so that's good.
Okay, yeah, which will be updated. so
Yeah. All right.
The
So,
only thing I would say there, though, that I look at it, it says saying the attorney should be denied. Change should to may. I think that's probably a bit
Yeah.
strong.
yeah. Yeah, step 11.
Serious violations, okay. Should be denied, maybe.
Okay, yeah.
Too strong.
All right, do we have to formally approve the revision of both the 3 arbitration advisories and the basic training?
I think so, because there's a revision date at the bottom of
Okay.
I thought I saw some typos on page 1.2. I think the advisory number is incorrect, the one that it references.
On the basic?
21402.
On the correction of the award?
Yeah, I think it's 214.01. I don't know.
Oh, I got it right here.
You have it?
214.
I don't think so.
There is no 02, it's an
Yeah,
01.
so I think it's 214.01,
Yeah,
and the date is
the amendment,
July
yeah.
25th,
Yeah.
2014.
Yep.
2015.
Right.
Okay, so that's a typo.
What are you saying about me
and
when you
then
talk
the
about
reference
you
to
starting
the
100 years ago with a much higher brand number than
Oh,
mine?
Isabel, this is 14, not 15.
I just feel that way, okay?
It's 14.
Two knee replacements and a shoulder replacement, I feel that way, okay?
So, and then down here, it references 2003-02, which was superseded by 2014-01. And then we have to change the name of that one, and the date on that one is the same. Yeah,
Yeah.
so those sites to the arbitration advisories are incorrect. It's the same advisory,
Yeah,
2014-01.
right, exactly, yeah. All right, we'll change those. All right, is there a motion to approve the edits on the 3 arbitration advisories and the basic training subject to receipt of the Shepherd-Mullen paragraph from Joel and Ken?
So moved.
Second?
Second.
All in favor? Aye. And they're gonna get the paragraph to,
By the end of the month.
does the committee want to see the paragraph before we approve it? Or-
So we're not in a hurry to.
Okay,
We
all
can
right.
send
We'll
it
give
to
the
Isabel and then she can
paragraph full faith
circulate
and
it.
credit.
Okay. I thought you said there was a training coming up or something.
Yeah,
But we only have sites
So
in the training,
arbitration,
right?
yeah,
Okay.
on that point, Ken, we've got to get anything we do with the Shepherd Mullen done by the next meeting, because that last meeting, Mrs.
She
Mark
said
and
she
I will
wants us
be
to get it
in
to-
Iceland.
Yeah, she said she wants us to get that to
Yeah, in a
Isabel by
month.
the end of
So
February.
you're gonna get it by
Yeah.
So we need
February.
to work on it the next couple of weeks.
Is there
Okay.
28 days in February?
I'm with you,
All right,
Yeah.
as long as you start.
all right. I'll send you a draft. I'll keep it under 5 pages.
You're not kidding when you say that.
That back is the
And
way.
you,
Oh, really?
Still not
My
working.
email's still down.
Yeah. Still
all right, I think we're on, agenda item D6. Discuss other MFA program materials requiring updates. I don't know,
That was just a catch-all.
catch-all?
Yeah, and, the documents I enclosed
Were just suggestions because they looked a little older. I don't know if you want to take a look at it. At a minimum, I do think that we should modify the language because it references a program director of fee arbitration and that position no longer exists.
I'm sorry, what are we doing now?
Okay, so we're trying to determine what other materials need updating.
Like, do you want to look at
And-
the model rules? Do you want to look
Right.
at like the really cornerstone foundational documents like guidelines and minimum standards, arbitrator requirements? Is there anything that you'd like to take one more look at or haven't looked at in a while?
So what's included in our
So what
agenda
I
are the
included-
guidelines and minimum standards.
Guidelines and minimum standards. There was also
Minimum qualifications for arbitrators.
I could also bring back the model rules if you want to take a look at the model rules again.
Wow.
These are just ideas, so if you want to brainstorm about other things you'd like to take a look at.
I don't want to put the lame in the lame duck here, but all of those things that you just mentioned would require the whole up to the board and public comment and all that kind of stuff, and I just don't think we have the time for it, and
I don't know that these documents would be subject to public comment. That's something that they're still working out. I know the arbitration advisories, Donna is trending
25,
towards
26.
having the advisories go to public comment before they go to board approval. These documents have always been put before the board for approval. I don't know if public comment will be inserted before that.
Well, but still, if we bring it on, the next meeting is
May 3rd.
May. And then when's the next Board of Trustees meeting after that?
There's one mid-March, and then I think there's one mid-May. But we can always do the working groups too after, as a gap between end of June to COPRAC, and then even then COPRAC, the MFA seats would only be for the advisory, so we would still need to use the working groups.
Okay.
Oh, there it is. Oh, repealed. Repealed. Well, we have to have volunteers to do this, and so if we don't have anybody that wants to do it. it's
Or
sort
if
of
you
a-
don't think
sort-
it's
sort-
necessary.
Or, yeah, it's sort of a non-starter.
Well, I just had a question, because I was looking at it on page 146, subparagraph 5, this is talking about mediation. The minimum standards have to have a procedure to preserve confidentially afforded by Evidence Code section 1152.5. I was just questioning, I don't know what 1152.5 is.
Well, we just looked it up, it says repealed, so,
Okay, then
yeah.
Well, that's
That's
one
why
of those
this is
mediation
here.
guys.
Well, the 1120, the mediation one's in 1120 section.
Right,
I
there-
don't know what 1150, I thought it was a type.
1152 is the settlement offers.
But it's repealed.
She just looked up, it says 1152.5 is repealed.
They're all in 1126. 1126,
Is that a typo? Is it
Yeah.
1126.5?
Yes, we did.
well, no, it existed, it was
Okay.
repealed, so I just Googled it.
One other thing I think it needs to be checked is this, under mediation, that subsection 2 where it says,
Are you on a specific page, Sharon?
let me see what page.
There's a page number in the lower
It's,
right.
page 145, where it says mediators have completed a minimum of 25 hours. About a year ago, we updated it to 40 for the
yeah.
LA County Bar, so I don't know if that's accurate. You gotta have somebody check it.
Well, this is what it is existing, it's 25, so,
That's a minimum, right?
right, minimum, right. So, getting back to the question, you know, it looks like just a cursory reading of these that we're doing here on the fly, that they need to be updated, but we need someone to
I
volunteer
don't
their
know
time.
I just looked it up here on, it says 1152.5 was repealed and continued without substantive change in 1123. So since there's no substantive change, I think we could just change that from 1152.5 to 1123. I don't know if we need, I don't know.
Do you want to just go through what's in our packet and see if there's any other code sections that jump out? I think the 6200 references on 143 are still good. .144, I don't see any either code sections or rules. 145. There's a reference to a removal.
This is
Removal to the state bar.
Rule of procedure, that should be accurate.
25 is 25, but, you know. 146, that was 1123, Ken?
Yeah. I have a question under 8, which is I guess it's the mediated settlement agreement. It looks fine, except it doesn't track the award part where, 30 days after the agreement, it accrues interest.
Okay.
We should probably include that.
Because the model fee mediation rule doesn't include interest either, I don't think.
It doesn't.
Because when we did San Mateo, and I did the track changes, it wasn't there, and we
But we
added
put it in,
We put
yeah.
it into San Mateo, but not
Yeah.
to the model
Oh, I
mediation rules.
remember that, I remember
yeah.
that.
So we can bring the model fee mediation rules and add it.
'Cause that could
there.
that could be an enforcement problem.
Right.
We've had that issue. If they don't put the interest in, the court won't let us have it, so.
So do you want to bring that,
To make it uniform with what we passed for
right.
San Mateo.
Yeah, so in the guideline, it should say that, and then in the minimum or the model rules, it should say that. I was looking up this Sharon, what was the part you were talking about? I was
The
looking up.
25 hours on minimum standards for mediation 2.
Yeah, I thought it was,
I thought it was
I
40,
thought it was
but-
40. I remember
thought it
we
was
had that.
30.
I said, we changed ours to 40. Our guy,
Are you
Jack
sure?
Guess-
Cause our thing is for 30, the next mediation
Jack,
thing?
when we redid the rules for mediation, he said that it changed to 40. So that's why I said I think it
Why don't we
needs to
just
be
track
checked,
what
because
took
I
the
didn't look
mediation
at it at the actual statute that he took it from.
I'm not sure where they are, but.
Oh,
But
mediation.
the
oh.
mediator
Model
training
mediation
thing that
rules.
we're doing is only for 30 hours.
It's 40,
Really?
yeah.
I thought I saw 30.
You know, we didn't post those to the website. In fact,
They're
we
not.
couldn't find them, and then remember, Nick and I found them in our emails.
The model rules aren't posted on the website either.
No, they're not.
so. I
But-
assume you've got the model mediation.
No, we
rules.
we
Right,
dug
I
we dug
found
them
them,
out.
yeah.
I
Nick-
found them
Nick
in my
sent them to
emails.
me,
Nick found them.
because I didn't see it on our shared drive.
Right.
So we just need to see what they say.
Yeah.
I remember we had that debate was 25 versus 40.
Well, maybe we could bring these two back.
Right, it's just a catch-all provision that we can add things to,
Nope, it's 40.
as the year goes.
Yeah.
Nope, it's 40.
Minimum didn't we go over this in San Diego for minimum qualifications for arbitrators? Although you look at these applications all the time.
I only brought it back because it's
I
over
don't,
10
I'm
years
not allowed
old.
to.
Who is that arbitrators now?
Chair. Oh,
I
for
don't- I
arbiter, oh,
don't-
no, I'm
I
sorry, I
don't.
was talking about, I was thinking about the committee. Yeah, we redid these, didn't we? Are these the updated ones, or?
Yeah.
Yes, revised January 12th, no, 2007.
No, I thought we looked at these.
Is there a more recent one?
Was that for the committee or for the arbitrators?
I think it was the committee. Now I think
Yeah.
about it. I mean,
I
are these
I
still?
thought there was an update for the committee appointments.
No, that was committee appointments, which is now moved.
Yeah.
My only suggestion for this one is that we, instead of saying program director of the State Bar of California's Office of Mandatory Fee Arbitration, we switch it
Oh,
to fee
whatever it
arbitration
is.
staff
Yeah.
or
Yeah.
something more
That's
general.
neutral, yeah.
Right, because the department keeps, and staffing keeps
Yeah.
changing.
So where does that appear?
In the first paragraph, so I would strike program director and then just edit it so that's fee
Program
arbitration
staff.
staff. Mhm.
Yeah.
And then on page 140,
There isn't a program director, is there? Or?
we're under professional
Staff.
competence, which
Yeah.
is a larger umbrella, but the program is just me and
Yeah,
Liz.
but I don't know, there's nobody that has that title anymore, I guess.
I don't think so, no.
So we'll change.
We're
direct-
nested underneath professional competence.
1 year ago today, Doug had that title.
Yeah, and then it appears again on.
They're having too much fun up there.
Page 148 under subsection B. You're supposed to report to the program director the existence of any criminal conviction. So
Change
report
that to
to
staff.
State Bar MFA staff.
Yeah.
I think that's
Okay.
labor code.
I invited him to the meeting to celebrate, but he's at the Super Bowl.
So should we bring these two back just so we can look at the edits
Sure.
for the May meeting?
Do you want to add the fee arbitration model rules and then the model fee mediation rules?
I just remember doing that.
I don't think the model rules need any updating.
Yeah.
I don't think, because we didn't cite rules of court or anything in there.
Okay. But you want
They actually had a whole like state bar consultant that was hired to do that.
Oh, okay.
That was like
Well, that was the state bar rules.
Oh, state bar rules.
No, that's the bar rules, yeah. But for the fee mediation, the model rules don't have the interest provision, I don't think. So I can add that in.
Yeah.
And then I'll-
Might as well attach them, you know.
Yeah, I'll
so
attach them
so we
with
can
it,
look
so-
at them.
Okay.
The model rule has the interest, is that what you're talking about?
Fee mediation
Oh, fee mediation.
for the stipulated.
No, those never got
The mediated.
got on their system. Okay, we already discussed 7, which is the LACPA changes. So I didn't see the next meeting listed on our agenda, but I believe it is May 3rd in Los Angeles.
That's what I have on my calendar.
Can we go back to the PowerPoints for the training materials? And then also Andrew has the paragraph for the sample fee
Oh,
agreements.
okay.
Yeah, so why don't we tackle the fee agreements first?
All right, so what pages on the PowerPoint are you?
Well, Andrew has language to share on
Oh,
the
okay.
flat fee.
Okay,
So why don't
do
we
that
take care-
first?
Yeah.
Oh, did he just, I was gonna say, it looks like Joe Namath.
Look at his face.
Wow.
Under his skin.
Sun damage. Does it look like a little bit like Joe Namath?
Kinda, yeah.
Yeah.
Flat fee. Okay, this is going under the no clauses part.
So, do you want me to present what this is?
Yeah, please.
Right. Following our conversation this morning, as you'll recall, I had a few suggestions or recommendations about the flat fee section, which is currently on page 38 of your meeting materials. And this is just a suggestion. If you don't like the format, certainly modify it. I tried to retain, I worked with Randy to do this, and we tried to retain much of, if it was Ken or the committee's drafting of this approach. But, and it's also a little condensed, because if I put in one extra hard return, it would have been on 2 pages. So we can work on the spacing if
Okay.
you so choose, but I wanted just to get it all on 1 page. And what we have attempted to do is clearly break out the 3 options in which a flat fee may be used. And option 2 and 3 give the options or the examples for when a flat fee is paid in advance and the lawyer is not and the lawyer is requesting that it go into the operating account as opposed to the client trust account as required by the new rule. And option 1 can be further massaged with any of your suggestions, but that's really any other type of flat fee arrangement. And so that's conceptually why we have it as options 1, 2, and 3.
And each option is a standalone?
That's correct.
Okay. Joel?
First read, I like it, except I would switch options 2 and 3. I mean,
You would make,
cases of a flat fee for $1,000 are gonna be the vast minority of all this kind of stuff, so I would emphasize where they exceed $1,000.
Oh, sort of had them in descending
Yeah, just
order,
switch those 2
monetary,
options.
yeah.
Make that option.
Call
Yeah.
option 2, 3, and call
Right.
option 3,
Yeah,
2.
because less
Yeah.
than 1,000 is the rare,
Yeah, but other
rare,
than that, I like this.
yeah. I'm still sort of reading through, so.
sure. And of course, if you guys want to take this back at your next meeting, I understand it's a substantive change. If you wish to consider this between meetings, maybe Ken or someone else might have further suggested edits, and you could, of course, take those up at your next meeting. You're not being sandbagged to take this, make a decision on this right now.
I'm with Joel. I'm with Joel. They look fine if we just switch 2 and 3.
Just for point of clarification, 2 is simply to show it's only written disclosure. That's all it's required under the rule when it's less than $1,000 or less. 3 includes client consent. I did make the edit we talked about earlier, which is reflected in the second sentence of all of these, which is this fee is fixed and constitutes complete payment for the services. Complete payment for the performance of services under this agreement and does not depend on the amount of work performed. I ended the sentence there. I tried to do this initially as red line strikeout so you could see appreciate more of the changes, but it was really too marked up. I just decided
Yeah,
to
we
come down
went
clean.
back and forth on that too, and as I said in my email to Ken, my brain was hurting.
Yeah.
Means I was successful.
Maybe it was on purpose. All right, well, with the suggestion that we flip 2 for 3, is there a motion to approve the flat fee proposed language from Andrew?
I so move.
Is there a second?
Second.
All in favor? Aye?
Aye.
Aye.
All right.
Thank you, guys.
Thank you.
So now we have, I don't know if we formally moved to approve the updated sample fee agreements with the mediation disclosure form, but why don't we do that? Is there a motion to approve the updated sample fee agreements under agenda item D1?
So moved.
Joel so moves. Is there a second? All in favor? Aye. All right, that's done, that's great.
Is this, can we then get these back on the website, or?
I think they have to get approved by the board,
Oh, okay,
so that'll be more mid-March.
okay. Yeah, because I know they pulled them, so.
They should be back up with a disclaimer. They moved them to a different section.
Oh,
I'll take a look.
maybe, I think they were gone, but maybe they hid them.
All right, does anybody have any other new business or any other
Say something about the
comments at 2:46?
PowerPoint.
Oh, PowerPoint, you wanted to do PowerPoint?
Anahita and I can figure it out.
Yeah.
It's just taking screenshots, and there is a rule reference. I can figure out which that one is. There's a ABA code DR 2-106B under reasonable fees. I don't know if that's still good.
ABA, huh?
Yeah.
I don't know why we're citing the ABA.
Where is that?
It's on page 140, the top left slide.
Oh, ABA, huh.
So I'll update the web screenshots, and then also screenshots of the new.
I would say get rid of that. Why are we citing it? I don't even know what DR
I don't know what that
stands
stands for. Should we just take out?
Just
and
take it out.
Replace it.
Yeah.
And just update the
Yeah,
rule
the
of professional
fourth one will
conduct.
do that, yeah.
Okay. And then I'll do the screenshots of the new form that we approved last year for the PowerPoint, because this is of the old one with the drop down boxes. and
Oh, right,
things.
yeah.
The only thing is, on the new form, there is no reference to 6203D for responsible attorney.
I'm sorry, which new form are we talking about?
On the findings and award template form,
Is that in here
it
somewhere?
just says, for the purposes of this arbitration award, the responsible attorney is blank.
As
I don't know.
opposed
I
to-
don't know if we need to cite the code section, but I mean, if we need to add it to the PowerPoint,
Because it's in the PowerPoint with the 6203, but it's not on the sample
On the
form that I
form.
sent out to all the local bars.
Was it there? But I don't remember it ever being there, was there?
It was on.
it was
previous
there because I remember
versions,
the
yeah.
form that Doug wanted us to use had it. I think
Why-
the
why-
concept is you want to identify
Right.
a lawyer as responsible.
Yes.
Okay, so as long as
Why,
you're okay
why
with
did
Yeah.
it come out of the sample award form?
because the current sample award form we have doesn't have the Business and Professions Code site.
I'm guessing that was an oversight, or
So I don't know if you want to change the PowerPoint to reflect the current form. Do you want to revise the form to to reflect what's currently in the PowerPoint. That was in the previous version of the template form.
If it's not too much to
What
add
is-
it,
this
you know, I think we just put 6203.
Okay.
Yeah, right here.
Okay, to have it reflect.
This is the one that Lee and Anna had worked on.
Aaron's really kicking up.
As part of the training stuff or the?
No,
word
just a
form?
form that we're using now.
Oh, okay.
All right, well, if there's no other business, the meeting is officially adjourned at 2:49.
Okay, Nick had to leave early. He asked me to say goodbye for him. His original flight was canceled and he had to take an earlier flight, so
We didn't even notice he was gone.
I'm gonna tell him you said that.
Isabel?
Yeah.
I don't know if you got, I abstained from the thing on, with Andrew's, revisions or whatever.
Oh, okay.
Flat fee?
Yeah.
Okay.
The flat fee, okay.
And is there a bathroom open